Hello, good morning. Ma'am, dungog ko ninyo, ma'am.
Yes, sir, you may begin.
Okay, good morning, everyone. And I hope everyone has had their breakfast. Good luck to all the debaters as well as to our respective adjudicators. Prepare your wits and your prawns and your minds because we will, in a while we will witness the wits and the clashes of the debates. So, ladies and gentlemen, welcome to the 2021 Dean's Cup, the Inter-Campus Debate Tournament. To start with, let us have an AVP for our invocation and national anthem.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين بسم الله الذي لا يضر مع اسمه شيء في الأرض ولا في السماء وهو السميع العليم. In the name of Allah, with whose name there is protection against every kind of harm in the earth or in the heaven, and He is the all-hearing and all-knowing. Allahumma ameen, 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 ya Rabbal Alameen.
Dear Lord, we praise you and worship you today. You are exalted in our midst. We ask forgiveness for every sins we have done. Have mercy on us, our Father. As we start our program today, let your guidance and protection be upon us. Send your Spirit to us and give us wisdom. We thank you for all of the blessings we have received. We also thank you for the lives of the people in this place. Be glorified in everything we do. In your name, our Lord. Amen.
Mga kababayan, ang pambansang awit ng Pilipinas.
Kayang magiliw, ewas ang sinakanan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, tuyag ka ng magiting, sa manlulupin, di ka pasisigil, sa nagagang tutok sa simoy at sa langit mong pagaw, ay hinatang tulad, awit sa pagkayang minamahal, ang isang ng matawad mo'y tagumpay na nagtitindig, ang bituin at araw niya kailan ang ay di magtitindig. Luman ang araw ng walhagin pagsinta, buhay langit sa piling mo. Ang inigaya ng pagkay mga aking, ang mamatay ng dahil sa'yo.
Okay, to give us her welcoming address and also to give us the overall guidelines for the debate, let us all welcome Ms. Charity Jean C. Abugan, the chairperson of the 2021 Dean's Cup Steering Committee.
Thank you, sir. Distinguished panel of adjudicators, Attorney Mann, Prosecutor Lau, and Attorney Alexine Bangcola, good morning. Dean Annabel Cañizares Mindalano, participants, members of the steering committee, audiences, supporters, good morning. If my recollection serves me right, this is yet the second Dean's Cup, however, the first time to be conducted in the new normal, as they call it, or through an online platform. Unlike to that of the very first Dean's Cup back in 2017, this year's event is far different and challenging in almost all respects. However, and in spite of those abrupt changes, the limitations, and the challenges brought about by the migration to an online platform, it did not stop the possibility of having this year's Dean's Cup. Truly, and in my humble opinion, we have lived the attributes of an MSU1, which is being resilient and innovative. With that, Mindanao State University College of Law Iligan Extension Campus, with the undying support of the Office of the Dean and the Assistant Dean for the Iligan campus, and in behalf of those who tirelessly work to make this undertaking a reality, I humbly welcome you all to this year's Debate Cup, the Inter-Campus Debate Tournament. I will not hold you long, and let us enjoy the competition. Once again, thank you and good morning.
To introduce to us the panel of adjudicators, let us all welcome the President of the Supreme Law Student Council, Mr. Fritz Ronald Amparado.
Thank you, Sir Rafi. Adjudicators, virtual viewers, good morning. I will introduce the set of adjudicators for today's inter-college debate. We have 4 panels for the 3 panels for the elimination round and 1 panel for the final round. For the first panel, our first adjudicator is a graduate of AB Consular and Diplomatic Affairs as cum laude at De La Salle College of St. Benilde. She is also a recipient of Benildian Excellence in Scholastic and Talent Scholarship and also a Student Leadership Award. Her Juris Doctor, she graduated at Iligan University School of Law way back 2019. She also received the 8th Honorable Mention Order of the Flaming Arrows. Her notable achievements in her debate experiences are of the following. In June 2019, she was awarded as the top 2 best adjudicator Philippine Law Debate Championship at San Beda University. In December 2008, she was with the champion team together with Ariana University School of Law at ANC Square of the Firm Debates. In September 2018, she was the best speaker at ANC Square of the Firm Debates, first, second, third elimination rounds. She has worked in various government offices since 2015. At present, she is a faculty of Mindanao State University Main Campus, College of Law, Mindanao State University. Virtual viewers, ladies and gentlemen, our chief adjudicator for this first round and for panel A, let us welcome and give her a lot of heart reactions to Attorney Asiana Alexine Adia Amira Labi A. Bangcola. For our second adjudicator, she is a well-respected motor while in the College of Law. She is also the editor-in-chief in Law Gazette, and as well as she's into creative writing who has published sport stories, feature stories, and she's also into photography. In fact, she was even able to did a short documentary, and she is currently Associate Provincial Prosecutor at the Office of the Provincial Prosecutor, Lanao del Sur. She is a graduate of AB English at Mindanao State University, and also she graduated her Juris Doctor at the same college, College of Law, Mindanao State University. And she is also a graduate of Master of Laws. And ladies and gentlemen, our next adjudicator is none other than Prosecutor Lauren Lau. A virtual round of applause and a heart reaction. Good morning, Prof.
Morning.
And our third adjudicator. He is a private law practitioner and an associate lecturer of the Mindanao State College of Law for the past 15 years. He holds office at the Acharon Man and Associates Law Offices in General Santos City. His law partner is Attorney Loreto Ton Acharon, the incumbent vice mayor of the city. As a law professor, he teaches various law subjects including constitutional law 1, 2, political law review, civil and criminal law, and other law subjects. He is a past president of the Rotary General Santos City and a member of the Gensan Toastmasters Club. He is a trying hard golfer and also a blogger. He lives in the same locality with his lovely wife, Ma'am Maria Lourdes Fernandez, and their two beautiful daughters, Miss Liz Abigail and Miss Adrienne. Ladies and gentlemen, virtual viewers, let us welcome our third adjudicator for panel A, Miss Attorney Leonard Mann. Let's give him a virtual round of applause and heart reactions. That is it for our panel A. I will now turn the virtual stage to the chairperson of the panel of adjudicators for round 1, Attorney Alexine Bangcola.
Thank you very much for those kind introductions. May I now call this House into order and call the debaters. On the affirmative side, we have Mindanao State University Iligan campus, while on the negative side, we have Mindanao State University General Santos campus. They will now debate on the motion. Let it be resolved that the 60-40 equity rule on business ownership be amended. We now call on the first affirmative speaker. You now have the floor for your constructive speech.
One of the most essential qualities of a good policy is it should be dynamic. It is also true that policies are deliberately worded in a manner that shall embody the past, reflect the present, and anticipate the future. This is to make policies more malleable in light of new conditions and circumstances, and in cases where amendments call for necessity. The affirmative will argue that it's time that we look into a new model in business equity ownership and set aside what seems to be not working for the longest time. In our model, we would allow foreign investment to be utilized as a coping mechanism of the state of a backward economy. We would allow foreign investors to have 100% ownership rule on businesses except in mass media, practice of professions, and manufacturing of nuclear bombs, which are constitutionally protected. What we are really after, ladies and gentlemen, are businesses that are profit-driven, that can significantly help the country. We will only allow and be opening this to countries who will grant the same privilege to Filipino companies because, of course, we respect and we're after the principle of reciprocity. The underlying consideration in this partial sovereignty is the reciprocal commitment of other contracting states granting the same privilege and immunities to the Philippines, its officials, and its citizens, ladies and gentlemen. I have 2 points of argument in this debate. First, I will argue on the constitutionality of our model. And second, I am going to prove to you that it is urgent because of the kind of conditions that we have, ladies and gentlemen. On the first argument, on its constitutionality, 60-40 equity business rules of ownership is a protectionary policy reflected since the 1935 Constitution. And we will say, ladies and gentlemen, that this is an absolute protectionary measure that does not work in the Philippines in the new context. Reflected in Tanyada versus Angara, Ispena versus Zamora, and even Manila Prince Hotel versus GSIS. The provisions of Article 2 and 1987 of the 1987 Constitution, the Declaration of Principles and State Policies are not self-executing. Legislative failure to pursue such policies cannot give rise to the cause of action of courts. The court further explained in the case of Tanyada versus Angara that Article 12 of the 1987 Constitution lays down the ideal economic nationalism by, number 1, expressing the preference in favor of qualified Filipinos in grant of rights, privileges, and concessions covering national economy and patrimony in the use of Filipino labor, domestic materials, and locally produced goods. As a general rule, ladies and gentlemen, there are no restriction to the extent of foreign ownership export enterprises. In domestic market enterprises, foreigners can invest as much as 100% equity except in areas included in the negative list. But we think, however, that the negative list is too restrictive, that it becomes less appetizing for foreign investors to invest in the Philippines. But if we can maximize the participation of foreign investment,
Mr. Speaker, excuse me. Mr. Speaker,
yes,
I have a question. Is it not true that the 60-40 rule can be found in the Constitution, particularly in Article 12, Sections 10 and 11?
yes, we acknowledge that it is constitutionally written, but we think that if we will to interpret the law as what I have said in the opening, I've told you that the framers of the Constitution decide or worded the Constitution in a sense that it could be malleable depending on the circumstances that we're facing, ladies and gentlemen. And we're telling you that right
Therefore,
now,
Mr. Speaker,
yes.
since it is the Constitution that provides for this 60-40 equity rule, we do not really have any other choice other than a constitutional amendment. Do you agree?
Yes, we recognize that, Your Honor. But what we're pushing here, ladies and gentlemen, is we want to make sure that that the Philippines will not be left out on the current trend that we have in the global economy. At the end of the day, the framers of Constitution wants to secure the Filipinos, wants to secure the Philippines at large, and when national interest dictates, we have to be we have to be very mindful of the actions that might be able to bring the Philippines on the higher flight, ladies and gentlemen. Let me proceed. We think that it is urgent, ladies and gentlemen, because of the pandemic that we're facing. If we were to take a look at the current financial liability of the Philippines, it's now amounting to $10.13 trillion. The debt to GDP ratio, which reflects the ability of to pay obligations, will jump up to 58.1% in 2021. These numbers translate to years of payables that even those who are yet to burn will have a share of these payables. Philippine debt increased to 6 trillion in July alone. The Philippine government's debt climbed further to 11.6 trillion in the end of July as the country borrowed more fund programs and amid failing revenues, and it is expected to grow even more, ladies and gentlemen. If we were to allow the inflow of the foreign domestic investment, we can be able to compete and we can be able to get along with the ASEAN countries. Such, for example, Thailand has 12 billion FDI. Vietnam has 34 billion FDI, and Vietnam is even now considered as the next China because it considerably growing because of its considerably growing economy, ladies and gentlemen. If we were to take a look at the history of Brazil, they were able to suffer from great crisis back in 1973, but they were able to cope up because they allow, same with the they allow foreign investments to
Mr.
uplift
Speaker.
them on their current situation. Thank you.
Thank you very much, Mr. Speaker. Time's up. We now call on the first negative side speaker to deliver his or her interpellation. You have 2 minutes.
Good morning, Mr. Speaker.
Morning, Council.
All right. Is it correct that you are proposing 100% equity share to foreign direct investment? Is it not?
Yes, we are.
Do you believe that FDI is significantly contributing to our real GDP?
Yes.
Do you know how much percentage does FDI contribute to the real GDP of the Philippines?
Enlighten me, please.
All right. So FDI is just only contributing 4.17% only according to the globaleconomy.com that was actually presented in the different countries using different countries' statistics. And my third question is, Do you agree
That's not
that
in the case
more
of Thailand. That's not in the
do you,
case of Singapore and
Mr.
Vietnam.
Speaker, do you agree that more FDI means more growth to the economy?
Yes.
But that is not actually what happens in Taiwan and South Korea. And my last question is, do you have an idea of the real intention of FDI?
Mm-hmm.
All right, so that ends
Sure.
my question.
Thank you very much for your interpellation. Once again, calling on the first negative side speaker to deliver his constructive speech. You have 7 minutes.
Good morning, Your Honors, to our Board of Adjudicators and to the affirmative side. Good morning. Real and sustainable development cannot be guaranteed by having higher foreign direct investments in the country. Thus, it will just open an idea of denationalizing on major industries, which the government to lose control over its productions and distributions. This means greater threats on local economies and a rape to our constitution. Foreign direct investments or FDI are constitutionally recognized in the Philippines. According to International Monetary Fund, the IMF defines FDI as a cross-border investment in which an investor that is a resident in one economy has control or a significant degree of influence on the management of an enterprise that is resident in another economy. For this reason, the Philippines has ordained and included in its promulgation the provision that caters the idea of private partnerships, particularly the stipulations on Section 20 of Article 2 of the 1987 Philippine Constitution, which states, and I quote, "The state recognizes the indispensable role of private sector, encourages private enterprises, and provides incentives to needed investments," end quote. Restrictions and prohibitions were in fact expressly entailed to limit the activities and definition of what is private sector and their indispensable role to nation economics gains. This is because when FDI exceeds to local economic assets, this will end up to debunking the idea of sole creation of the Constitution. The affirmative side, Your Honor, would want us to believe that the country's development can be realized if we amend the constitutional ratio of 60-40 equity rule in business ownership that will favor the foreign multinationals in international corporations to invest in the country. For them, they equate more foreign direct investments as tantamount to greater development. However, Your Honors, this act had overlooked the very intentions of our legislative bodies in passing Republic Act 7042, amended by Republic Act 8179, or the Foreign Investment Act of 1991, which main reason, Your Honor, is to protect the essential patrimonial reservation of our country that is or that should be utilized and be enjoyed by Filipino people. Your Honors, this attempt on amending the prescribed equity shares has failed to recall that it will cause in losing the country's stronghold over its foreign policies as well in its economic policies. And in fact, this course of action will eventually result to allowing foreign investors to engage in activities which our laws have directly set prohibition and restriction and were enumerated in the Foreign Direct Investments Act of 1991. The main reason cited by the affirmative side is the development of a stressed economy brought about by the pandemic. But the prerogatives on amending the supposedly restrictive economic provisions of 1987 Constitution, Your Honor, and to liberalize foreign direct investments or FDI into the country will not necessarily mean economic recovery at all. And it was just
Mr.
only cause.
Speaker,
Yes, Madam.
yeah, the trend in international trade on goods and services is to open the barriers to this trade in goods and services. Why do we need to restrict foreign direct investments when
Actually, Your Honor, we have already set a 40% engagement to our foreign direct investment. And I guess that is not actually a restriction at all. We are just prohibiting them to enter into another ventures which they can lead at the end of the day to which our government will lead at the end of the day losing its control over its
like
productions and
Mr.
distribution.
Speaker,
Yes, Madam.
like for example, the the Philippine Negative List requires that there should be 100% Philippine citizen equity in mass media. But do you think that's already quite archaic in the face of social media? Even if we restrict 100% ownership in mass media in the Philippines, Filipinos can avail of has access to mass media outside of the Philippines, which are not Filipino owned.
Actually, Your Honor, I believe that to actually that Your Honor would the answer to that, Your Honor, is actually we as Filipino enshrined in our constitution, we are destined to actually utilize the resources that was actually found in our country. And the 60-40 equity, Your Honor, is fair and justifiable. And I'd like to go back that the country is greatly affected by the pandemic, and that is undeniably true. But our economy has remained resiliently perpendicular. The status quo is very clear, Your Honors, that despite the surge of the pandemic, Philippine economy with less than FDI equity shares has still surpassingly strong. According to the data from United Nations Conference on Trade and Development Database, published by Avon Foundation on January 19, 2021,
Mr. Speaker,
provides
Mr. Speaker,
yes, your
is it
yes,
your
sir.
position that our country, the Philippines, does not need foreign direct investments?
We are not saying that, Your Honor. What we are saying is at least the 60-40 equity share that we are practicing now is justifiable and square for them, Your Honor. All right, so I'll go back. The
Mr.
countries of
Speaker,
South, yes, Your Honor.
uh, like, would you want for Jollibee when they go to the US or in the Middle East or even in Europe that only 40% of Jollibee will be owned by the Filipino corporation that owns the company?
I guess on that note, Your Honor, that depends on a particular area, Your Honor, because when we say the Jollibee Filipino-owned corporations would want to invest in another country, they should have to follow the restrictions on ownership on that particular country, Your Honor, I believe. All right, so the two no industrialized countries, which I mentioned, South Korea and Taiwan, um, have significantly grown their economy by just having small FDI inflows ranging from 0.5% and has contributed 7 to 10% of this of their country's real GDP growth, given the time of less than 15 years in 1970 to 1984. This was in contrast of the FDI in the Philippines that ranges from 1.6 to 2.0 from 1994 to 2019, given the time of more than 2 decades with real GDP growth ranging from 3.6 to 6.6% only, and that is 30 to 45 less than the GDP growth of South Korea and Taiwan within 14 years. With that statistical numbers, we can say that increasing FDI will not guarantee economic advances on the economic side of the country. Your Honors, the Constitution is very clear on its mandate in Section 19, Article 2, to quote, "The state shall protect a self-reliant and independent national economy effectively controlled by Filipinos," end quote. We believe that increasing the FDI in the country would mean decreasing the abilities of our local competence in doing business, Your Honor. And the study conducted by our Organizations for Economic Cooperations and Development in 1991 reveals that the risk of having big FDI in a developing country is prospectively great. This means control over which industries are solely relied to foreign investors. We, from the negative side, Your Honors, do not see the necessity of amending the 60-40 equity share on business ownership in order to solve the pressing economic issue that the Philippines is facing right now. Hence, it will just offend the fundamental principles of the Constitution. To emphasize, Your Honor, Section 9, Article 2 of 1987 Philippine Constitution states, then I quote, "The state shall promote and a just and dynamic social order that will ensure the posterity and the independence of the nation and free the people from poverty through policies that provide adequate social services, promote full employment, a rising standard of living, and improvement of quality life for all," end quote. The question now would be, is the proposed amendments on 60-40 equity rule in business ownership necessary to a declining economy? The answer is no. Instead, it will just worsen the level of the dependency status of the countries to nourish their own potentials as a great nation. At the end of the day, Your Honor, why do we need to fix when it is not yet broken? And that I end my case.
Thank you very much. We caution all speakers to be mindful of their time and not to go over time. We once again call on the first affirmative side speaker to deliver his interpellation. You have 2 minutes.
All right. Good morning, Council.
Good morning.
I would appreciate you answering yes or no only. On my first question, you understand that by allowing these foreign investors to be here in the Philippines also means that they are still subject for the law of land. That means that they will still have to register to BOI, register from to SEC, and pay their taxes and BIR, right?
Absolutely, but I am looking into its
Yes.
impact to
So
our
thank
economy.
you. So that also means that by paying more taxes and providing more employment rate to the Philippines at large will benefit from these foreign investors, right?
How sure are we that
Yes
you're
or
going
no?
to
Yes or no, council,
no?
please.
How sure are we that they are going to employ
All
our
right. So,
laborers
all
here?
right. Let's move to another question. Are you aware of the case of Tanyada versus Angara?
Please enlighten me, Your Honor.
All right. On that case, the Supreme Court already stressed that allowing this foreign investor does not necessarily mean that we are denying the local or domestic markets or domestic industries to grow or to be competitive. In fact, allowing them will help the domestic markets to be more competitive globally. All right. Next
What is
question.
there to be fixed?
Next question. Are you aware that the Philippines has now an increasing debt in IMF? Contrary to your claim, it's amounting to 11.6 trillion on the end of July alone.
Yes, but I guess that
Do you
wouldn't
recognize
answer
that?
by FDI. Yes,
Do you
but I guess
recognize that? And
yes,
you
but I guess it
recognize
wouldn't
that?
be
Do
addressed
you
by
recognize
FDI.
that the only way that we can be able to pay these payables is by limiting the governmental borrowing, right?
I don't think so.
All right. So if not, governmental borrowing can only be limited by establishing sound economy. No further
But
questions.
FDI would not guarantee that.
Thank you very much. We now call on the second affirmative side speaker to deliver his or her constructive speech. You have 7 minutes.
Good morning, Your Honors. I'm Rahima Biguro, and I will be arguing on the benefits of our policy. But first, I have a few clarification with regards to the initial engagement of the first speakers. When Your Honor asked whether or not the 60-40 rule was in the Constitution, we agree that it is actually indicated in the Constitution. But under the statutory construction, it's important to interpret this provision as a whole and not for specific texts only. And this provision states, for example, that the 60-40 rule is only amenable when it is in the interest of when it is according to the national interest. And right now, there is no proof coming from the affirmative that the 60-40 rule has been serving the national interest of the Philippines. They also argued that the 4.17% is the only figure that exists with respect to the contribution of the FDIs in our GDP. But we think that while this is a small figure in their manifestation, this 4.17 actually manifests that the reason why it's very small is because we are very restrictive in our policy. So I will proceed with my benefits. First, how it benefits the government in its goal to achieve national patrimony. And second, how it benefits the vast majority of Filipinos who have long suffered from the shackles of very conservative economic policies.
Ms. Speaker, before you proceed, I'd just like to ask a question. Perhaps I'm just splitting hairs, but you said statutory construction. However, is it not that this provision is in the Constitution? Is your team's position that this provision, there is room for interpretation with respect to this provision? And as a follow-up question, I would like to ask finally, what exactly does your team propose to do? Are you just saying that we need to interpret it in a favorable manner, or are you pushing for constitutional amendments? Thank you.
For that clarification, Your Honor. The provision provides that in the Constitution that the 60-40 rule can only be applied when the national interest dictates, which means, for example, that this is not a self-executing provision. So we need to create policies that are actually according to the national interest only if the 60-40 rule provides for that. So this necessarily means that since it is constitutional under that provision, we only need to provide policies and not necessarily a charter change, a constitutional change. So I will proceed with my first benefit on the argument on why it's beneficial for the government and its goal to achieve national patrimony. We stand with this jurisprudence of the Supreme Court that the amendment of the 60-40 rule is a stepping stone in creating a more liberalized economy, Your Honors. Of course, this doesn't mean that the amendment will automatically mean that our GDP will skyrocket the next day. Like every progressive vision, this will happen gradually. And the benefit is that the amendment creates a stimulus for legislators to finally introduce more laws that accommodates FDIs. Why is this a government action? In fact, in 2001, the president removed the 40-year state protectionism on retail. And even in the following year, the president also signed the Electric Power Industry Reform Act, which removes power generation from the list of public utilities so that it cannot be subjected to the 60-40 rule. This means that as far back as 20 years ago, our government already concedes that the 60-40 rule is problematic, and they are doing everything they can to bypass this rule to attract investments instead of amending it. Even the World Investment Report in 2009 rated us with a negative 4.1 rating in our inward stacked and growth rate among ASEAN countries. So we don't see why the figures provided to you by affirmative bench is necessarily beneficial, or it does not necessarily trickle down to the vast majority of Filipinos, which leads me to my second argument. Why is this beneficial to the vast majority of Filipinos who have long suffered from the shackles of conservative economic policies? What does this mean, and what does this look like? This means that instead of sticking with status quo, where we only have the Zobel Ayalas, the Henry C's, and the Lucio Tans as the frontliners of oligarchy, we now create stimulus to challenge the economic structure that only benefits the elite minority. My third speaker will talk about the practicability on establishing competition among this corporation. What I want to highlight right now is the reason why, in the first place, the Filipinos who suffered the brunt of only having domestic corporation as the only available providers in the market, and why it's beneficial to abandon that kind of economic model. The first sub-analysis is the expansion of labor. As of date, the unemployment rate of the country is at 93.13%, and even pre-pandemic, we weren't really in a better place. So it's safe to say that with our policy, attracting foreign corporations will create more jobs, because by then, our choices are no longer limited to the subsidiaries of SM Investments, Ayala and San Miguel conglomerates, or the Philippine Airlines and the like. When you expand the opportunities for your people to enjoy power to participate in the economy. And this is beneficial because, in the first place, the reason why most qualified Filipinos are unemployed is not because we are not qualified, but because we do not have enough opportunities to be hired. And the oligarchs have preyed upon this vulnerability because, for as long as the 60
Miss Speaker, don't you think that the Philippine economic zones already host foreign direct investors?
Yes po. The Philippine po already hosts for FDIs, but the problem is we are too restrictive that other potential investors are actually shying away from investing in our country, and it's affecting the Filipinos in terms of the employment rate in our labor and other investments that are necessary. So the oligarchs have preyed upon this vulnerability. We think this was evident when Honda ceased operations in Laguna and people lost their jobs. The Wells Fargo, for example, withdrew in the Philippines and transferred their jobs and opportunities in India, followed by more MNCs. And the common denominator is that they are citing the business climate and restrictive policies of our country as a reason. So what is the safeguard then for Filipino workers who have lost their jobs? There is nothing. So the benefit of labor expansion is not just a band-aid solution to put food in the table. Labor expansion changes the dynamics of the market, because when consumers have the purchasing power, we are no longer seen by corporations as disposable human beings, but as stakeholders who participate in the market and to whom they
Miss
owe
Speaker,
quality protection and
Miss
services.
Speaker,
Yes.
you said that one of the reasons why this business has closed down is the business climate. So it does not necessarily mean that the 60-40 rule is the reason why these businesses are closing down, right?
Yes po, Your Honor. Aside from the business climate, they also cited the restrictive policies of our government. That's why they actually migrated their businesses to other countries. So,
But it is not the primary and only reason, right? The 60-40 rule.
yes po, it is a factor and a big one po.
Thank you very much for your speech. We now call on the second speaker of the negative side to deliver his or her interpellation. You have 2 minutes.
Good morning, Madam Speaker. How are you today? Are you fine?
Yes, good morning.
I'd like to command your obedience by saying yes or no, all right? So let's start with the interpellation. So let's use the words of the first speaker. Do you believe that policies must be dynamic?
Yes, Your Honor.
Do you believe that being dynamic means being flexible and inclusive?
Yes.
Now, is dynamism equated with the preservation of national identity?
Not all the time, with national interest dictates.
Okay, enough. And do you propose change on the Constitution? You've mentioned earlier by means of statutory construction as your argument. All right, did you read the Article 12 of the Constitution? Did you understand the wisdom of the framers of the Constitution?
Yes.
I will educate you about that later, but let's proceed to the next question, Madam Speaker. For this, I think, yeah, for a while, are you in the position of amending the 60/40 equality rule on business ownership, Madam Speaker,
Yes, of course.
to provide economic opportunities in the Philippines?
Yes, of
Yes
course.
or no? The Constitution mandates to have a self-reliant economy, correct?
Yes.
And presently, Filipino corporations control local economy, correct?
Yes, if we can.
Okay, and allowing foreign entities to participate more than the 60/40 scheme will be beneficial for economic globalization, correct? Yes or no?
Yes.
No? Yes. Yes, is your answer. And then the foreign corporations, do you believe that they're more powerful than the Filipinos? I mean the Filipino corporations.
No.
No. All right. So do you agree that there is a need to really empower the foreigners? I mean the foreign investors, to the FDIs.
Sure.
Okay. Do you believe that there is also a need to balance our relations between? All right. And that simply puts into record that we need to balance the 60/40. All right.
Time. Okay. Thank you very much for that. We now once again call on the second negative side speaker. You may now deliver your constructive speech. You have 7 minutes.
When the heart breaks, it hurts a lover. But if the loss serves its purpose and you try to fix it, it doesn't make sense. To our dear adjudicators, spectators from the different parts of Mindanao, and all citizens included in this virtual discussion and the clash of arguments, good morning. I'd like to start my argument by destroying the arguments presented by the first two speakers from the government side of the House. First, the necessity speaker kept on telling us that there is a need to change the 60/40 scheme because it is a way to link economic development and to cause economic development in the Philippines. There have also been contentions that the economy of the Philippines is also very restrictive, citing the Constitution as one of the factors which is actually limiting the economic opportunities. I beg to disagree, and I would like to dispose that contention simply because it is obviously devoid of justification. There is no scientific or at least direct and logical explanation that FDI is directly related to the GDP. That has already been negated by the first speaker of the negative. Now, they have also mentioned that less restriction in the Philippines is important, but they have failed to substantiate their claims. They have only cited the economic benefits, but they have not presented the links between these restrictions or these additional restrictions and its effect to the FDI inflow. Now let me proceed. I have two arguments. First, that the restriction provided by the Constitution is a prospective mandate designed to benefit the Filipino business while being Filipinos. And second, that reforms in policies are needed to take place first, as change in the 60/40 business equity rule may negatively affect the sensitive parts of our economy. On to my first point. The restriction of the foreign ownership is in our Constitution is its mechanism to protect. Yes, po.
What is this sensitive parts of our economy that will be greatly affected by?
I will discuss about that later, ma'am, but I would like to drop the environment and natural resources as an example. But I will discuss that later.
Will there be environmental laws enough to protect the environment of the Philippines in
With the
case of
status
foreign
quo,
investment?
with the status quo, Your Honor, there are already laws in existence. But apparently, there are data which would prove that there are also big violations committed by FDI companies in the Philippines, which the Philippines find difficult to settle, even if there are existent laws. The problem is with the enforcement, Your Honor, and thus there is a need to revisit the policies.
In other words, it is the enforcement that is problematic.
Correct, Madam.
Not really the FDI.
Exactly the point, ma'am. May I proceed now, ma'am?
Go on. Yeah.
We are now in the argument of whether or not this provision of the Constitution is still beneficial. We say yes in the negative. While liberalizing the economy through foreign investment, the value of restrictions has never become outdated. Let me cite the case of European countries and how much they value, or the value they accord to the imposition of this restriction. Pertinent to the FDIs, apparently the European Union member states that the need of collective actions to regulate FDI inflows, as there are not simply a matter of doing business, but rather a venture which may either make or break the economy and the politics of the country. There are various mechanisms acknowledged, such as ownership and percentage restrictions to protect the security of the state. Restrictions are anchored on the idea that openness to foreign investment does not come for free and conditions. There are important yet sensitive portions of the economy, yes.
Mr. Speaker,
yes,
are
sir.
you aware of the term oligopoly?
Not totally, sir.
Mr. Speaker, it is a state of limited competition in which a market is shared by small number of producers or sellers. Perfect example, Mr. Speakers. Now, look at this Zoom meeting. There are many of us here who do not have their videos because there are only two leading communication networks in the Philippines, particularly in Mindanao, right?
Yes, sir.
So why don't we open up foreign investment so that there will be more competition, there will be better services, particularly for our networks, communication networks, Mr. Speaker?
We have already opened it, sir, but on a limited scale because we still prioritize the Filipinos. There is still the wisdom of the Constitution always tells us that we have to prioritize the Filipino first among others.
Do we have the technology, Mr. Speaker, for this particular species or business enterprise?
We don't have the technology, all the technologies yet, sir, but we have all the mechanisms through the laws in place, and at the same time, the institutions we have created, like the DOST, all it needs is proper allocation and proper prioritization.
Thank you, Mr. Speaker.
You're welcome, sir. Let me proceed. Is there any point, sir? In fact, let me cite the case of Iceland. Iceland is very much restrictive with its FDIs. In fact, there is a very, very high amount of ownership they accord to their citizens, and there is always a priority to the local businesses. What is worth emphasizing is despite the restrictions of the Iceland with maximum of 49% ownership for foreigners, they still managed to bake it on top of the economy. Now, Iceland's focus is on the production and manufacturing, and it helped its economic environment by empowering its people first. So it's more on the internal rather than focusing on what the outsiders can give. Second, the contention that the FDIs are correlated with GDP is a myth. I have already said that. Next, reforms in policies are needed to take place first before we do this change. If in case we do this change, the FDI has several issues, including the environment or environmental impacts. In fact, as I have stated earlier, the Global Alliance for Incinerator Alternatives revealed on 2018 that in the 6 major cities of the Philippines, the six of the 10 major polluters are from foreign direct investment. I am pointing out that with the status quo alone, the gigantic FDIs have been manifesting delinquency in complying or following completely the environmental laws that we have. Similar findings have been released, and that tells us that if the system is not really working, why do we have to find more problems?
Thank you very much. We now call on the second speaker of the affirmative side to deliver her interpellation. You have 2 minutes.
Thank you, sir. I would like to start with my interpellation. First question, are you using PLDT as your service provider right now?
I'm using Globe, unfortunately.
Okay, so are you aware that PLDT, only 9% of PLDT share stocks are owned by foreign corporations?
No, I'm not aware.
Exactly. So you should know by now that the reason why we don't have better internet is because local providers don't have the incentive to give us a better service because they don't have competition, right?
No, Madam Speaker, there are other factors which may actually call for more foreign investors aside from that. So it's about the policy, not the PLDT or the competitors.
Are you aware of the Build, Operate, Transfer law?
Yes, but I think I have a little bit difficulty of recalling everything.
Agree that it has failed to institutionalize public-private partnerships in government infrastructure programs, right?
Come again? I'm sorry.
You agree that it has failed to institutionalize by public-private partnership in government infrastructure programs. Do you
Well,
agree?
apparently, I have no fact to say as a basis, so I abstain in answering the question.
Now you are already informed of that. So are you aware of the cabotage law?
No? Enlighten me?
So you do not so you are not aware that it has also failed to address increasing transportation and logistic costs because it is a protectionist policy.
I may
Yes,
not
sir.
be aware, but I'm sure that the increased FDI restriction is not the solution to address that problem.
But in the contrary, you have also not provided other solutions. So do you agree, for example, that in order for us to expand labor, we need foreign investments? Yes or
We
no?
need for... Come again, sorry.
Do you agree that in order to expand labor in our country, we need foreign investments? Yes or no?
For the meantime, the Philippines is one of the worst places to work with according to a data that has been presented by international surveys. I would say policy first.
So you are actually conceding right now. So are you aware, for example, that we have so many debts in World Bank and IMF, and we have no
Of course,
capacity?
I'm aware. Yeah, that's something that...
Thank you very much. We now call on the third speaker of the affirmative side to deliver his or her constructive speech. You have 7 minutes.
Ladies and gentlemen, your honors, good morning. Lest we be misconstrued, the affirmative side is all for a self-reliant Philippine economy. But the reality is, we do not exist in a utopia, we are not in a perfect world. That is exactly why, in these trying times, we need to make drastic measures to address the needs of our country. Allow me to answer 3 questions first before I proceed to my constructive. First, what has been the solution of the government to combat the steady decline of our economy, especially with the hit of the pandemic? Second, to which side do we better serve the intent of the Constitution? And lastly, do the fears of MSU Gensan in this debate hold water? First, what has been the solution of the government to combat the steady decline of our economy? Because it seems like the negative bench in this debate seems to turn a blind eye on what is existing right now and in reality. They seem to understand and push forward the idea that foreign direct investments won't have any effect at all in our GDP or the economic growth as a whole. This is where the affirmative side wins this debate because we clearly told you that by increasing the equity threshold for foreign investments, we open our doors for foreigners and direct investors, and we open the possibility of competition at large. This means that the local businesses right now in the Philippines will be on their feet and they would have to innovate and provide more resources and provide jobs to existing Filipinos because now another competitor would be entering the market. As mentioned, of course, also by Attorney Mann, when we talk about Article 12, Section 10, the Congress shall, upon by recommendation of the Economic and Planning Agency, when the national interest dictates, preserve the citizens of the Filipinos, the 60-40 equity rule. So let's just use the statutory principle of verbal legis. When the Constitution already provides that when the national interest so dictates, it is upon our legislative bodies to enable or to provide executing laws and enabling laws, enable for us to provide a more efficient solution to whenever the national interest dictates. Further, let me cite Article 2, Section 4, that the prime duty of the government is to serve and protect the people. This is the primordial responsibility of the branches of the government and for us to be able to attain sustainable development at large. Second question, which...
Mr. Speaker,
Yes.
so is it your position that it is practical now to amend the
Yes.
Constitution on this 60-40 rule, considering that we are in the midst of a pandemic, and to have an election or plebiscite for this purpose will entail billions, if not trillions of pesos to conduct these elections?
Okay. Your Honor, we humbly submit that there is no need to amend the Constitution when the Constitution already provides that when the national interest dictates, there is a power given to the legislative body to enact laws that will be able to attain a self-reliant Philippine economy at large.
But we already established earlier, Mr. Speaker, that the 60-40 rule can be found not just in statutory or issuances or laws, but in the Constitution itself. Article 12, Sections 10 and 11, correct?
Yes, 10 and 11, yes, Your Honor. But as what the previous speaker have already told you, that the Constitution must be taken as a whole and not just by a provision. We have to take into consideration that these articles are only precedent, and there is one leading, and that is the primordial responsibility of the government to serve and protect the people. And right now in our pandemic, the only way to do so is for us to be able to get resources. Even since we cannot get it locally, we have to outsource and take drastic measures to address the pressing needs of our country.
Thank you,
Okay.
Madam Speaker.
So, okay, third question. Do the fears of MSU Gensan hold water in this debate? We disagree because their fears are really misplaced. We understand that there is a possibility that these foreign investments might try to exploit our natural resources and the like, but we already have existing regulatory bodies that provides the mechanisms to ensure that even with a grant of 100% ownership to these industries, they will not be abused in one way or another. Through them, we are able to safeguard our democratic institutions, and our labor sector will not be exploited by these individuals. Under our framework, we in the affirmative side submit that such endeavor to amend the 60-40 equity rule is practical for two reasons. Number one, this will allow Filipino citizens to use and enjoy these foreign investments to further explore and develop our untouched resources, like that, for example, of the Liguasan Marsh. And secondly, this will be in keeping with our international agreements with the other countries and in line with Pacta Sunt Servanda. Because of number one, because of our dwindling supply of energy, there is really a pressing need for us to pursue and exploit our internal or our natural resources in the Philippines. However, we lack the technical and fiscal capacity to be able to do so. This is exactly why we need the influx of foreign investments to enable us to exploit these kinds of resources. Yes.
Yes, like if we restrict, for example, the entry of foreign brands, like let's say it's an and other foreign brands in the Philippines, this industry will be dominated by Filipino capital.
Yes, Your
And
Honor.
would work well for Filipinos. What do you think, Ms. Speaker?
Actually, it will be a healthy competition to the existing brands and local businesses here in the Philippines whenever we try or whenever we open our doors to these international brands, Your Honor.
So, like if I say, for example, we restrict H&M, so we'll just have Filipino-owned brands like Bench, Pen Shop. All right, what do you think? Isn't it good for the Filipino and the Filipino economy?
Under competition law, it will not be
yes,
healthy.
okay.
Because whenever there's no competition, then there will be a monopoly, which is not a healthy kind of economy at large.
Okay, continue. Thank you.
Second argument is that this will be in keeping with our international agreements and Pacta Sunt Servanda. We emphasize that what is enshrined in Section 13, Article 12 of the Constitution, and I quote, "The state shall pursue a trade policy that serves the general welfare and utilizes all forms and arrangements of exchange on the basis of this equity." For that, we are proud to propose.
Thank you very much. We now call on the third negative side speaker. You may now deliver your interpellation. You have 2 minutes.
Morning, distinguished judges, fellow debaters. The question is for Madam Speaker. Is there a doubt in the interpretation of the constitutional provision on the 60-40 equity rule?
Excuse me, come again, Mr.
Is there a
Speaker?
doubt in the interpretation of the provisions found in the Constitution on the 60-40 rule?
No,
Precisely,
there's no
so there is really no need to interpret or amend the Constitution based on doubts on statutory construction, as what you have been telling us for quite some time now. So is there, may another question is there no enabling law that embodies the 60-40 rule? It's found in the Constitution.
What we're trying to amend, sir, is to amend the enabling law itself, because there's already an existing provision in the Constitution that when the national interest dictates, we are able to amend the enabling law.
Precisely, Madam Speaker, because your side of the argument, including the other speakers, are pointing that there are no enabling law and the provisions in the Constitution are not self-executing, and they are precisely pointing to the fact that there is no enabling law
There
to
is not, Mr. Speaker, because the SEC regularly checks these kinds of capital structures.
Madam Speaker, another question is, do you mean we have to declare a constitutional provision unconstitutional without the
No,
need
not
for constitutional amendments?
No, not necessarily. When the Constitution already provides the entire phrase when the national interest dictates, Your Honor.
Precisely, Madam Speaker, because the point of your argument is that the bone of contention of your argument is based on statutory construction when there is no doubt in the interpretation.
I think you were not listening, Mr. Speaker, because my partner have already told you that we're not necessarily resorting to statutory construction because the law is very clear.
Thank you, Madam Speaker.
Thank you very much. We now call on the third negative side speaker. You may now deliver your constructive speech. You have 7 minutes. Sir, you are muted. Please turn on your...
Good morning, esteemed judges, colleagues, ladies and gentlemen. It seems that our esteemed debaters from the other side does not believe in the capacity of the Filipino people. To reiterate our stand, the 60-40 rule on business ownership should not be amended. The institution of the restriction in foreign investment and ownership in the 60-40 ratio enshrined in our laws is not designed to limit foreign participation in nation building, nor strangle the aegis of development through globalization, but a policy to regulate investments and business of foreign firms and multinational companies in the country. The purpose of the law is evident. That is to promote a self-reliant and independent national economy effectively controlled by Filipinos, practically implemented by leaving the administration of socio-economic and political affairs to the Filipino, as aptly and competently established by the gentlemen on our part. In a 2000 UN CDP background paper entitled Economic Globalization, Trends, Risk, and Risk Prevention by Gao Xiangguan, the participation of developing countries in the globalization process poses enormous risk. According to some report published by the UN in 1999, the number of developing countries that have benefited from economic globalization is smaller than 20. In 1960, the value of foreign trade, the poorest 46 countries accounted for 1.4% of the total investments. Towards the latter half of 1990, this proportion lessened to 6%, and further down to an almost negligible 0.4% in 1995.
Mr. Speaker,
Yes, ma'am.
We have an example of two countries, no, with a restrictive and a liberal economy, the North Korea and the South Korea. Don't you think that the South would show that, freer inflow of FDI is better than a more restrictive policy on foreign direct investment, as can be seen in the North Korean model?
Indeed, esteemed adjudicator. However, our side of the house does not, to reiterate, we are not against the influx of foreign direct investment FDIs through multinational companies, but to regulate their ownership of the business interest in the Philippines as espoused under the law.
Okay.
And towards the latter half of the 1990s, this proportion lessened to 6%. And over 80% of the capital are flowing among U.S. Western.
Mr. Speaker, are
Yes,
you
Your Honor.
aware of the rationale of this 60-40 rule in the 1987 Constitution?
Yes, Your Honor.
What is the rationale of this rule?
The rationale of the rule, as found in the deliberation of the Constitutional Commission in drafting the law, is to instill a self-reliant economy free from the shackles of economic abuse from or an unbridled economic abuse, probable economic abuse by multinational level companies if left unchecked, Your Honor.
Mr. Speaker, considering that the 1987 Constitution is now 34 years old, older than us, Mr. Speaker, do you think the rationale of this Constitution still applies today, considering the globalization that had been happening for the past decades?
Yes, I still believe, Your Honor, because the the spirit of the law in that sense, from the 1935, 1973 to 1986 Constitution, this provision has never been was left untouched. Precisely, Your Honor, because we are supposed to, even though the law is dynamic, the spirit of the law is keen on intent on preserving for the Filipino people the governance of basic industries, Your Honor.
Thank you, Mr. Speaker.
In the same study, UNCPD study that I mentioned ago, there are evidences that unregulated open economies lead to socio-economically oppressive situations. It was shown factually therein that the increasingly globalized world economy is in a free and drifting state. This is to a great extent very similar to a domestic economic situation of developed countries in the West in 1930s. The Mexican and East Asian financial crisis in 1990s and the collapse of the long-term capital management companies call for a globalized Keynesian economics and establishment of corresponding institutions to exercise effective interventions in the world economy, particularly the functioning of international market. Your Honor,
Mr.
ladies and
Speaker,
gentlemen.
yes, pandemic restrictions has shown us when we restrict economic activities. Don't you think, like, yeah, if you limit the number of, customers that a restaurant can take in a restaurant, for example, this means also contraction of business or sale. Now, the same case with FDI. If we only limit, investors to Filipinos, if we badly need foreign capital to, fund certain sectors in which the Filipinos may not have the capital or may not have the technology knowledge uh, uh, to invest in, don't you think that we would need foreign investors, higher equity for investors in certain sectors?
To reiterate, Your Honor, I agree with the proposition. However, there is a ocean-wide difference between restriction and regulation. And Your Honor, the purpose of the law is not to restrict the influx of multinational level companies or foreign direct investment, but to regulate their ownership of vital business industries in the Philippines. The law is replete with statutory safeguards in ensuring the Filipino first policy as espoused in the Constitution. So in a long line of decided cases in the Supreme Court, there is Ichong versus Hernandez, Manila Prince Hotel versus GSIS, Gamboa versus Teves, Sanidad versus Sanidad. The law is clear that the ownership should be preserved to the Filipino people.
Thank you very much for that. We now once again call on the third affirmative side speaker. You may now deliver your interpellation. You have 2 minutes.
Hello, good morning, Mr. Speaker.
Good morning, ma'am.
Okay, so let's start. Do you recognize the fact that our country, the Philippines, is a developing country?
Yes, ma'am.
Yes or no?
Yes.
Okay. So the meaning of a developing country is that we need to work hand in hand with other nations for us to be one of those developed countries. Am I right? Yes or no?
That's right, Madam Speaker.
Okay. Are you aware about the issue of Leguasan Marsh?
Enlighten me, please.
Okay, so let me enlighten you. Leguasan Marsh is actually a petroleum exploration block within the enclaves of BARM that has yet to be explored because we lack the fiscal and technical capacity to do so. Do you think right now the Philippines, with our own resources, are we able to exploit these resources just on our own? Yes or no?
To qualify my answer, Your Honor, the esteemed,
yes,
no, I don't think we are not incapable of doing the
So is it your position, okay, so is it your position then, as you earlier said, that the influx of the foreign investments will be detrimental to the Filipinos? Am I right? That was your claim?
No, that is not my claim.
I think your previous speakers have already said that. Okay. So, secondly, do you understand the fact that, as what my first speakers have already said, these foreign investments will still be subject to the regulatory laws under our nation?
Yes, they should. They are. They are provided by law.
So clearly, Mr. Speaker, the fears of your side is misplaced because there are existing regulatory bodies that will be the check and balance for these kinds of investments.
Precisely,
Now,
I'm speaking.
Mr. Speaker, do you recognize the existence of these regulatory bodies right now in our nation, the BIR and the SEC? Yes or no?
Yes.
Okay. Nothing else, Mr. Speaker. Thank you.
Thank you, ma'am.
Thank you very much. We now call on the rebuttal speaker for the affirmative side. You may now deliver your rebuttal speech. You have 3 minutes.
Good morning, everyone. The argument of affirmative that FDIs do not have direct relationship with our GDP is something that we want to rebut. First, the low statistics that the opposing counsel presented is a constitution that we have low concession that we have low FDIs because of our conservative policies. Furthermore, you cannot judge the economic impact with figures solely. In fact, when affirmative argue that the FDI is not really contributing to the economy, then why do we have policies that are substantially in conflict with the 60-40 rule? This is because even the government recognizes that the importance of FDI in the economy, and right now we rank next to Palestine and Libya in terms of having the most restrictive policies. A company who specializes in a certain industry will of course want to operate on their own instead of owning just 40% of a business model that they have built for years. So in terms of viability, it is a reasonable expectation for multinational corporations to choose to operate in Singapore or Hong Kong, even if they want to invest supply chain in the Philippines because of our policies. So their argument on GDP vis-a-vis FDIs is immaterial in this debate. The only standing case that affirmative is holding on to, is negative is holding on to, is the Constitution, which we repeatedly told you has been unfairly interpreted by negative text by text. They are deliberately omitting the phrase that when national interest dictates, which we found misleading in this debate. So we are now past the debate on constitutionality. We have now advanced the debate on the effects of the amendment and lack of amendment thereof. So we have to stop thinking that as a third world country, we have the upper hand in this debate, because as far as debts are concerned, we have more debts than investments coming in for the past years, which means that we have to tailor our policies away from our obsolete laws and towards legislations that actually protects the working class and the poor. So I ask the opposing counsel, if we continue to tolerate rules that only serves the rich, then what is the point of arguing for a Filipino first policy if the only Filipinos that they are protecting are those who are already enjoying massive amount of wealth? We see Filipino first policies as something that is pro progress and pro investments. We don't agree that in the interest of preserving national identity, we need to see the Filipinos poor and middle class continually suffer from unfair economic status that has only benefited the 1% rich of the entire country. We believe that the method that negative is trying to aver in this debate, which is the 60-40 rule, is not aligned to the value that they are trying to defend. For all these reasons, we are very proud to propose. Thank you.
Thank you very much for that. We now call on the negative side rebuttal speaker. You have 3 minutes to deliver your rebuttal speech.
Your Honor, distinguished gentlemen, and from the debaters from the other side, the affirmative clearly did not present any argument to justify change in the status quo. And they did not present adequate policy proposal to change the status quo. They want to negate the constitutional provision by a mere statutory construction or a mere interpretation of the law. And finally, they have not stated that the policy is broken and have not presented any material evidence, empirical evidence to point that opening up the economy to foreign direct investment and granting them 100% ownership, that's what like the first speaker noted, did not correlate to the development or the development of the nation. So finally, they have not stated that, again, the policy is broken because they have been reiterating that, number one, there's no self-executing, or the provisions under the Constitution specifically pointing to the 60-40 business equity rule is not self-executing. However, these were belied by several cases. Manila Prince Hotel versus GSIS, Sanidad versus Sanidad, all cases decided by the Supreme Court stating that the transcendental importance of this constitutional provision does not need enabling law in the first place. They are self-executing to belie their claim. And they have been mentioning that their arguments are profit-driven. However, again, they did not substantially present any argument that would believe us, that will believe this body, or argue that their proposition would, if given or granted, would provide for exacting development or direct correlation with the development of the nation and growth of the nation being a developing country. I believe that they have misconstrued the law, and again, our position in this house: if the policy is not broken, why fix it? That's all. We rest our case, Your Honor. Ladies and gentlemen, thank you.
Thank you very much. Thank you to all debaters for your performance. You may now virtually cross the house. With that said, I will now turn over the virtual floor to the organizers. This signals the end of this first round.
Thank you. May I request our esteemed adjudicators to please go to the breakout room for your deliberation with one of the tabulation committees. Thank you.
Mr. MC.
Okay, may I now call on Attorney Bangpola, the chair of the first round of this debate, to announce the winner. Thank you.
All right. Once again, I am Attorney Alexine Bangcola. Before we announce the winners, we would like to just give a few first impressions. With me on the panel are Fiscal Lauren Lau as well as Attorney Leonard Mann. Fiscal Lauren Lau will give her impressions on the affirmative side. Attorney Leonard Mann will give his impressions on the negative side, finally culminating in me announcing the winners as well as points for improvement if that would be allowed. Organizers, would that be okay?
Yes, attorney, you may proceed na po.
All right, Fiscal Lau, the virtual floor is yours. Ma'am, nakamute po kayo.
Unmute po.
Okay. Again, take two. Good morning again. I was tasked to deliver my impressions on the overall performance of the affirmative side. Yeah, overall, you were good. But somehow, I would like to point out first speaker was a bit animated that sometimes the arguments get lost. What's happened to my get lost in the during the delivery. Yeah, speaker number two, I would encourage some more too subdued, more lively not lively. How do you more with more force when you make your arguments? No, the third speaker is good, very relaxed, but answering direct to the point. And the rebuttal, yes, bumawi naman si second speaker sa rebuttal. I think you have somehow rounded up a good rebuttal there, but I think you did not exhaust the time allotted. Sayang yung oras. You could have said so much in what one more than a minute ata yung hindi mo ginamit na oras. So yeah, you were good. It was a close call, but you did a good job.
Thank you very much, Fiscal. We now call on Attorney Leonard Mann. The virtual floor is now yours, sir.
Thank you, Ms. Chair. Good morning, everyone. And congratulations to all the speakers of the negative side. I really want the way you compose yourselves during interpellations and even during when you were asked questions from the adjudicators. And I want the energy of the first speaker. I think of the three, he was the only one who made use of hand gestures. Mr. Sopilanas, keep doing that because hand gestures make your speech, your content stronger. But perhaps you may want to avoid using this kind of hand gestures. It's very strong. You may want other gestures like open arms, like that. And may I suggest for all the three speakers to establish eye contact. In the online world, the only way by which we can establish eye contact, connect, engage with our audience, with the judges, is by looking at the cameras and not on the screens. Okay? So eye contact, looking at the cameras. And I like the opening statement of the second speaker, negative. Mr. Sol, can you repeat your first quotation in your speech? That's a very nice and effective way of opening a speech. Telling a quotation, famous quotation, or a joke
Sir,
to get the attention and to connect to the audience.
I'm ready to say it again, sir.
So go.
When the heart breaks, it hurts a lover. But if the law serves its purpose and you try to fix it, it doesn't make sense.
Yeah. I've read in the comments that really stuck in some of the audience. So that's all. Congratulations to you and good luck. And keep speaking, keep debating. You all did a good job. Thank you.
Thank you very much, Attorney. In my case, here are are my impressions on how the debate went, as well as some points for improvement sprinkled throughout my oral adjudication. First off, what all debaters in this round, as well as in future round, need to know or need to remember that in a legal debate, you have to balance both your legal analysis as well as your application. I'm not sure for other adjudicators, but in my case, as someone who has debated in this format, and as someone who has also adjudicated this kind of format for debate or legal debates in general, you have to be able to accomplish both objectives. In other words, you have to have the perspective of a law student, future lawyer, and that you are able to calmly apply your legal analysis, what you have learned in your classes, and at the same time convince or persuade the ordinary person, the ordinary citizen who may not be a lawyer, who may not be a specialist, as to the wisdom of what you are proposing, the wisdom of whether or not we should implement what your proposal is, or whether or not what you are proposing is more harmful or more beneficial than what is in the status quo. So that is one thing that you need to remember. With that said, I appreciate the contextualization that all of the debaters gave in this round. It is clear that you have done your research and that you have been very thorough with respect to how you researched on the economic situation of the Philippines and what we can do about it with respect to whether it is amendments in the laws or in the Constitution. So now, with that said, what every debater here needs to improve on is their foundations in legal analysis. I appreciated the research, I appreciated the facts, the empirical data, the papers that you used. However, you could have improved more on the cases that you cited and how you cited those cases. While I appreciate the citing of landmark cases like Tanyada versus Tuvera, GSIS, considering that these motions were already pre-released beforehand, I believe there were some specific cases that you could have used. The Supreme Court has a dearth of jurisprudence when it comes to the 60-40 equity rule. So really on both sides, I was looking for those cases and how they would be creatively used. So if it's a matter of percentage, all of the debaters, it was more of a 70-30 split. You focused really more on your analysis as to the context, your economic analysis. But as I said, your legal analysis could still use some improvement. So that's one. Second, there was I would not say lack, but again, you need to improve on your links. Both sides, in that the speakers in both sides tended to deliver claims, but they did not necessarily back up those claims. You back it up with data, but again, the analysis was lacking. And further on, like as the debate proceeded, you tended to adopt extreme positions. Like on the government side, you tended to say that FDA is good for the Filipino people, but we can only adopt FDA if we amend the law, amend the statutes so that we would get rid of the 60-40 equity rule. On the opposition side, as the debate went on up until the third speaker, it now seemed as if you were saying that FDA is not necessarily good for the Filipino people, even going so far as to say that FDA might be bad for the Filipino people by citing papers wherein you would say that it would prove that when developed countries participated in globalization, for example, it would not necessarily yield good results. So again, I would caution you to be careful with that, not just in debate, but even in the law. There are no such thing as extremes. You have to be able to engage with the other side. The point of debate is being able to persuade an average reasonable person. In other words, it is not enough to claim an extreme as something being absolutely good or absolutely bad. You always have to have a measured analysis and prove to the ones listening that your proposition edges the other's proposition by this margin or in this way. With that said, again, I hope that I'm not discouraging you with these comments, but I'm just speaking based on experience. On the part of the government side, personally, I believe that there was a fundamental misunderstanding with how the law or the constitution should be appreciated. So as a adjudicator and as a lawyer, I could not credit you for that despite how good your arguments may be. Perhaps if you had given an explanation or substantiation about how exactly, like on the practicality aspect, how exactly we can amend the law in such a way that it is still constitutionally sound without amending the constitution, perhaps I could have appreciated your arguments a bit better. This is a um, fundamental understanding that we have as a lawyers. The constitution is the supreme law of the land. We know that our constitution is a rigid constitution. It is not easily amended, and it requires a what do you call this? It requires a really good reason for us to be able to amend the constitution. Personally, I was not fully convinced that you or that we could amend just the statute, considering that repeatedly the adjudicators have mentioned that that specific provision is in the constitution. Actually, even others who would want to amend the 60-40 equity rule, they would always say charter change or amending the constitution. I have not yet seen a single proponent for the amending of the 60-40 rule that would only go so far as to say that you just amend the statute. Because as we very well know, the statute cannot go above the constitution. On the opposition side, I briefly touched on upon this actually. But again, be more measured. Do not just go to the extremes. Just because you are on the opposition side, it does not automatically mean that you take the position that FDA is automatically bad for the Filipino people. I do appreciate how you started by saying that FDA is not necessarily bad, but we don't need to amend the constitution or the existing laws, considering that we already provide enough through the 60-40 equity participation. So that would be a more measured stance to have taken. But I would again have appreciated more analysis on why you will not concede on those particular areas wherein foreigners really do not have a participation in, like mass media, for example, or in the case of public utilities, because that is definitely an area that should have come up in the debate. You would be saying that 60-40 is enough, but as I think it was Fiscal Lauren La who raised it in an interpellation question, what about those areas where the constitution states that there is no foreign participation that is allowed? So I would have appreciated more analysis on that you would have still stood your ground, that we should still abide by the constitution, and that we really cannot allow foreign equity in those particular areas. So with that said, I hope that these points will help you improve in the future. Considering what my fellow panel members have stated and what I have already also stated, the decision was actually very close. The best speaker for this round, majority of the adjudicators agreed that it was the third speaker of the affirmative side. Congratulations. This would be Ms. Akmida Mamakotao. Congratulations for being the best speaker for this round. In a split decision, meaning 2-1, we gave the win to the negative side. Congratulations, Mindanao State University, General Santos. So thank you very much. Good luck in your future rounds. I wish you the best.
So what's next?
Thank you so much, Attorney Bangkola. May I call on the MC to facilitate?
Okay. May I call again on our president for the Supreme Law Student Council, Mr. Fritz Ronald Amparado, to introduce to us our second set of adjudicators for the second round. Thank you.
Thank you, Sir Rafi.
So
For
first
the
round, you
second
can go
panel,
na. Okay na kami? We can
I think the
leave the
live
room now.
stream stopped. Admin?
It's still ongoing po.
Okay, I thought it stopped.
So we can leave for the panel A. Okay na ba? Kami mag-leave?
Yes, Prosec, if you wish po.
Okay.
Thank
Thank
And
you
then we'll
very
see
much.
you for
Just
the
join
championship
later.
rounds po.
All right. It's still at 3:30 p.m., no?
Yes, attorney, but we will keep you posted po kasi baka daw mag-extend yung legal forum.
All right. Thank you.
Thank you so much, attorney, and thank you so
Thank
much,
you,
Prosec Lau.
Project. Thank you.
Mr. Amparado, you may proceed.
All right. Thank you, Sir Rafi. For the panel B of the second round, our set of adjudicators are of the following. For our chief adjudicator, he is a graduate of AB English at MSU IIT batch 2006. He is also an alumnus of the MSU College of Law Iligan campus and graduated as cum laude and batch salutatorian of batch 2017 Persevero, garnering awards such as Debater of the Year, Mock Trial Outstanding Participant, Writer of the Year, and College Service Award. He passed the 2017 bar exams and admitted to the practice of law on June 4, 2018. He's a former associate lawyer at the Subihano and Litocalan law firm. Currently, a professorial lecturer at the MSU College of Law, Iligan City campus. He's also currently a senior partner at the Advincula Reyes Advincula or ARA law firm. Ladies and gentlemen, virtual viewers, our first adjudicator and chief adjudicator, let us welcome Attorney Michael Cesar Advincula.
Good morning, everyone. Thank you very much, Mr. MC, for that introduction. Good morning,
Yes,
everyone.
attorney. For our second adjudicator, she's a graduate of Bachelor of Arts in Political Science, class of 2003 in Mindanao State University, General Santos City. While working for her dream of becoming a lawyer and studying law, she was working in an NGO and Justice and Peace Desk Socials Action Center and in the law office of Beloncho Gule Law Office to support her studies. Eventually, she graduated and earned the degree of Bachelor of Laws and conferred with Juris Doctor class of 2008 in Mindanao State University, College of Law Extension, General Santos City. After graduating law, she worked as technical staff and consultant of the then Congressman Roy Logoles of Parañaque City in the House of Representatives, Quezon City, to save for the bar examination. After passing the bar, she went home to her hometown in General Santos City and put up her law office, the Ventura Law Office, and after 2 years, she entered the judiciary and served as a branch clerk of Court 5 of RTC 25, Coronadal City. Currently, she is an associate provincial prosecutor in the province of South Cotabato. Addicted to learnings, she studied Master of Laws in San Beda in 2017 and conferred the degree of Master of Laws Class 2021 in San Beda University, Manila. Ladies and gentlemen, virtual viewers, please help me welcome our second adjudicator, Prosecutor Mary Grace Ventura. Let's give her heart reactions.
Okay, good morning, everyone. Good morning to the debaters and good luck to the next round.
Thank you, Prosecutor. Our third adjudicator is currently employed as a court attorney in the Office of Chief Justice Alexander Gismundo. Before joining Chief Justice Gismundo's workforce, she was under the tutelage of then Chief Justice Lucas Bersamin. She has worked for 3 justices of the Supreme Court, including Associate Justice Jose Portugal Perez. Before joining the government, she worked as a junior associate in Ponce Inreli Reyes and Manalastas law offices, famously known as Pecabar. She was also an apprentice in the Angara Abelio Concepcion Cruz Regala law offices, distinctively known as ACRA. She is a graduate of the Juris Doctor program of Ateneo Law School and Bachelor of Arts in Philosophy of the University of the Philippines. Diliman, she has been debating since grade school but chose a different calling in law school, devoting her skills to her advocacies through human rights organizations and activities to hone her writing skills. But the debate arena has always been nigh. She would still participate as a speaker during former class debates and serve as an advisor to the PLM debate team. Working under the guidance of three Supreme Court justices, equip Attorney Nash to have an incisive and analytical mind, assisting in the drafting of cases that are now part of our jurisprudences, trained her to have a good command of the English language with eloquence and clarity of expression. She teaches special proceedings, conflict laws, statutory construction, special civil actions, alternative dispute resolution, and insurance law. Ladies and gentlemen, virtual viewers, our third adjudicator is none other than Attorney Nashmailin Marhum Salik. Let's give her a virtual round of applause and heart reactions.
Assalamu alaikum. Good morning, everyone. Good morning to my esteemed co-adjudicators. Good morning, speakers.
Morning, Attorney Nash.
Good morning.
Okay, may I now call on Attorney Michael Cesar Advincula. Sir, you have the floor.
Thank you very much. Allow me also to greet my esteemed fellow adjudicators, the Honorable Public Prosecutor Mary Grace Ventura, and the Honorable Attorney Nashmailin Marhom Salik. Good morning. And good morning to the debaters and to all of us here on this virtual floor. So may I now call this House into order and call the debaters. Are we all ready? If we are now ready, on the affirmative side, we have MSU General Santos Campus, while on the negative side, we have MSU Marawi Campus. They will debate on the motion, let it be resolved that any person with pending case cannot run for public office. So we begin with the first speaker from the affirmative side. You have 7 minutes for your constructive speech.
Thank you, Attorney. Good morning to our panel of adjudicators and to the negative side. And I will start my contention in this debate now. How can we clean something in the office when someone by which we are giving permit is soiled? Good morning to everyone. We are now faced with the motion, let it be resolved that any person with pending case cannot run for public office. We begin by defining the terms in this motion by pending case as not merely filed, but with probable cause after thorough review from the prosecutor, that is for criminal case, and for administrative case, which means ongoing trial, run as filing for certificate of candidacy in public office involving national and local elective positions, and prohibition refers only to the time when the pending case is not yet resolved. And the word cannot run doesn't automatically mean COMELEC disqualifications, but this is just an outcome after a summary procedure conducted by authority of which COC is rejected. Philippines, as a democratic country, recognize the right of the people to vote and be voted through election. With this, Your Honors, the very core of democracy is explicitly practiced. However, to some extent, running for public office, despite dissipated records, are becoming wounded and fad in our country today. Although the Constitution provides certain limitations on the disqualifications of candidates as provided by Batasang Pambansa bilang 881 or the Omnibus Election Code and RA 7160 or otherwise known as Local Government Code of the Philippines, but it must be given emphasis that public office is not a playground to run through politics, but a domicile for public trusts. It is very evident that the Constitution directs the accountability of public officials, and that is stated in Article 1, Section 1, Article 11 of 1987 Philippine Constitution, and I quote, "Public office is a public trust. Public officers and employees must all times accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. In this merit, the necessity of restraining person with pending case to run for public office. Otherwise, Your Honor, the word integrity will be useless in the declaration of law. Your Honors, we believe that this proposition is not a discriminative intention, but of constructive one for the country. The political options of the electorate in our country for countless times only evolves on as recyclable and hoary politicians, notwithstanding as corrupt officials. While the presumption of innocence is broken by guilt, public trust is negated by doubt. Presumption of innocence is afforded by law to all accused in general, Your Honor, and that is very clear. But this should not be worthy to a public trust if there is a slightest doubt. The presumption of innocence is personal while public trust is not. Presumption of innocence protects us from the unfair conviction which public trust doctrine protects public abusive rulers. We cannot extend presumption of innocence here, Your Honor, as to any person who would like to run for public office, because the case of public accountability is not between them and of the democratic people. The purpose of the presumption of innocence, which is found on the Bill of Rights, is to limit the power of the state and maintain the balanced power between the people and the state. If we are to wish that our officers be held accountable up to its fullest intent, presumption of innocence should not be applied. Prohibiting person with pending case from running for public office, Your Honor, is not a penalty to an ex post facto conviction. Hence, it is a prevention to have bad governance.
I'm sorry, Mr. Speaker. I may be allowed to, if I may, I would like to
yes,
ask.
Your Honor.
Sorry, just two questions for you. First, you mean to hold candidates for public office to a higher standard than presumption of innocence? Is that what you're saying?
Yes, Your Honor.
Okay. And you also mentioned earlier that one of the parameters in this motion involves national and local elective position. Is that correct?
Yes, Your Honor. Clearly correct.
Thank you. Thank you very much. Please
Thank you, Your Honor. Thus, the nature of such prohibition should not be considered as lack of arbitrariness, because it is reasonable and fair. Therefore, due process, which means the standard of reasonableness, is better upheld in our side. There is no reason on the ground why Philippines is always having bad governance. And that is because we are doing nothing to prevent it, Your Honor. And by this proposition, Your Honor, we are trying to prevent the corruption and the bad governance that our politicians are practicing long time ago. And to propose this kind of policy will create another landmark for Philippine good governance. Ladies and gentlemen, we are futuristically preventing cases like of which the Supreme Court held on Halushos versus Comelec regarding the preventing of facts during the filing of candidacy as mayor of the Pitan City, Zamboanga del Norte on May 2010. This landmark case, Your Honor, is an exact example that the affirmative would want to thwart as early as possible. The succession of power then is a delaying measure to consider for one elected official to conform with the finality of disqualification of one in case of winning in the election. This means a waste of resources, time, and delay of public services. Your Honors, this proposition is necessary as it will give justice to people to vote and
Mr.
choose
Speaker?
officials. Yes, Madam.
Good morning. Are you aware that there are frivolous cases, complaints, and petitions that are filed every time?
I am not that really aware, Madam.
Now you are aware. Thank you.
Thank you, Madam. Your Honor, again, this proposition is necessary as it will give justice to people to vote and choose officials free from doubts and bad intention for public. This policy proposal, Your Honor, will be very necessary then to change the constitutional provision more on the necessity of time. Now is the perfect time, Your Honor, to set clear and pro-governance practices or pro-governing practices to deterrence to erring officials or any person who would like to use the resources of the people and of the Philippines in general and the immunity provided by the state to escape legal liabilities and responsibilities. There is nothing but progress. In this is the core intention of this proposal. And by that, Your Honor, allow me to end this by saying
Thank you very much, first speaker for the affirmative side, for your constructive speech. Let's now call on the first speaker from the negative side for the interpellation. You have 2 minutes.
Good morning, Your Honors. Good morning, Mr. Speaker. First question, do you think banning these candidates with pending cases is the key solution to clean the government, Mr. Speaker? You're muted, Mr. Speaker.
Actually, we have set limitations, and as you can see, as you can hear on my first paragraph,
Well, I beg to
have
disagree, Mr. Speaker. No, blaming them or banning them is not the best solution, since there are a lot of politicians that we have in the Philippines right now who is actually engaging in corrupt practices, who do not have any pending cases. Second question, isn't it unfair for persons with pending case to divest trust just because they are subjected to a pending case?
I think it's no. They
It's
have to
unfair,
clean
Mr.
themselves
Speaker.
first.
You are
It's
actually
not.
already declaring them as guilty of the alleged crimes that they have committed.
You have to go back on my definition, Mr. Sir.
No, you've mentioned that the local government code is the domicile of public trust, and you've mentioned that you are already holding them accountable just because they are subjected to a pending case. Is it not, Mr. Speaker?
I don't think so.
And I beg to disagree. I believe that it is unfair for those persons with pending case to divest trust to them, upon them, because just because they are subjected to a pending case. Another question: were you able to read Batas Pamansabilang 881?
Yes, some part of it.
And
Yes,
I believe that you have read the Article 1, Section 12 of this law, right?
Yeah,
Which
particularly
provides
with
for the disqualification.
disqualifications.
Were you able to find persons with pending case as a disqualification for a person to run for public office?
That's why we
None,
are
right?
proposing. That's why we are
None. That's
proposing.
why proposing. That's why this motion or
For
your
policy
argument
change.
does not have any legal basis on arguing that on banning them from running for a public office, Mr. Speaker. Second, or another thing, were you or isn't it tantamount to declare him guilty since you are already disqualifying him to run for public office?
No, not
Those
at
persons
all.
with
But to give him chance to clean himself first before entering into the politics.
And I believe, Mr. Speaker, that it is not the best solution to clean the government since corrupt practices are already happening in various branches of the government. Thank you.
And
That
I
will be
don't
all.
believe what you believe.
Thank you very much for the interpellation. Second speaker from the negative side. We now first speaker from the negative side. Let's now hear the constructive speech of the first speaker from the negative side. You have 7 minutes.
Thank you. Your Honors, this debate is not only to argue about whether a person with pending case cannot run for public office, but a debate on deprivation on the exercise of rights and privileges of one individual. In the case of People versus Marawi Makabalang, the Supreme Court pronounced that the presumption of innocence of an accused in a criminal case is a basic constitutional principle fleshed out by procedural rules which place on the prosecution the burden of proving that an accused is guilty of the offense charged by proof beyond reasonable doubt. Your Honors, members of this most imposing congregation, salam and good morning. Article 3, Section 14, Paragraph 2 of the Constitution provides that in all criminal prosecutions, the accused is presumed innocent until proven guilty beyond reasonable doubt. This is the very reason why it is necessary to allow such persons with pending case to run for a public office. Ladies and gentlemen, pending any conviction, an accused is presumed innocent, entitled to all rights and privileges afforded by the state to its people. Unless otherwise expressly disqualified to exercise a right or a privilege, a person cannot be deprived of doing what he wants. And the same rule applies with running for a public office, ladies and gentlemen. Neither the Constitution nor the Omnibus Election Code of the Philippines does in any manner ban individuals with pending case to run for a public office. Hence, we on the negative side of this debate is proposing and strongly pushes for the preservation of the status quo where an accused is favorably looked upon by the Constitution and the law prior to the determination of the courts of his guilt beyond reasonable doubt. Your Honors, permit me to present the necessity of allowing persons with pending case to run for public office in this debate. First, we believe that allowing persons with pending case to run for public office is incongruent with the principle of presumption of innocence enshrined under Article 3, Section 14 of the Constitution. And second, doing so upholds and protects the integrity of the judicial system of the country. As to my first argument, the Constitution as well as jurisprudence will tell us that the accused is ought to be presumed innocent until and unless his guilt is established beyond reasonable doubt. In this case, or in the case of People versus Arguamon, ladies and gentlemen, the court reiterated the principle of equipoise doctrine in consonance with the presumption of innocence, which states that when the evidence of the prosecution and the defense are so evenly balanced, the appreciation of such evidence calls for tilting of the scales in favor of the accused. In this case, banning persons from running for public office merely because they are a party of a pending case is tantamount to assuming that they are guilty of the alleged crimes in the information. Hence, this ultimately violates Article 3, Section 14 on the presumption of innocence of the accused, since you are already assuming that he is guilty of the crimes charged. And even if you are not, ladies and gentlemen, depriving them of their right to run for public office without finality of judgment rendered by the courts of justice has no legal foundation and is a clear violation of the Constitution and a number of laws. Hence, it is necessary to maintain the status quo where the accused in a pending case is still given an opportunity to exercise their right to run for public post. This then essentially leads me to my second argument, which is when you disallow the exercise of the right of persons with pending case to run for public office, this is nothing but an equivalence of exercising judicial functions, thereby disrespecting the power of the courts. By exercising judicial functions, ladies and gentlemen, we mean that banning them from running for a public office is putting the accused in a trial when only the courts have the power and jurisdiction to do so. Hence, it is necessary that we afford them the safeguards provided under the law in addressing their case. That way, we reinforce the authority of the courts and at the same time, we uphold the integrity of the judicial system of the country. By law and by jurisprudence, your honors and ladies and gentlemen, it is inherent that the judiciary is the only branch entrusted with the power to determine the guilt of a person, thereby disqualifying him to run for a public office, and not any lawmakers in the country. By these reasons, we believe, ladies and gentlemen, that it is necessary to preserve the status quo where a person with a pending case is allowed to run for public office. With that, thank you and good day.
Thank you very much. First speaker from the negative side for your constructive speech. We now proceed to the interpellation by the first speaker from the affirmative side. You have 2 minutes.
Good morning, Mr. Speaker.
Good morning.
Are you aware or are you of the position that a person with his or her pending case in court running for public office should be presumed innocent?
Yes, I believe.
Under the Constitution, a person is presumed innocent unless otherwise proven guilty, correct?
Yes, correct.
The act of filing COC, is that a civil case in the court?
Yes.
Not a criminal case in the court as well?
What's your point, Mr. Speaker?
So those persons who filed the respective COCs are not filing it in court for that matter, correct?
Correct, yeah.
So they are not accused for that matter.
Yes, but you are already presuming that they are guilty
so
of the crime
therefore,
committed.
Mr. Speaker, they still
Yes.
have the right to be presumed innocent as their pending cases in court, but they don't have the presumption of innocence in filing their COC.
No, but you are actually depriving them of their right to presumption of innocence since you are already
Are you
assuming
familiar? Are
that
you
they
familiar with the
committing
concept of
crime.
preventive suspension?
Yes,
Are
I
you
believe.
familiar?
Yes.
Provided all the legal requisites, is it valid?
But is it safe to say that you are preventing them without discriminating them?
So meaning it is not violative of the due process clause. Am I right?
No, it's clearly a violation of the due process
Is
since
it
you
a
are
measure
putting them in trial,
to
Mr.
us not
Speaker.
to influence the result of the case? Is it correct?
No.
And therefore, since to prohibit a person with pending case in court to run for public office is preventive in nature and not a penalty.
It's
It is not
discriminatory in
violative
nature
of
because you
due
are already
process as
assuming
it is
that they are
reasonable
guilty since you
for
are putting them in
preventing the
trial,
person
Mr.
with bad
Speaker.
hands to hold the precious powers of the government, I think. Do you agree?
No, I disagree. It is a discriminatory policy and putting them in jeopardy as well.
That is not a discriminatory policy, Mr. Speaker.
It
That
is
is a
because you are already
preventive
assuming that they
policy.
are guilty since
We
you are
are
banning them to run for a
preventing.
public
We are
office without
preventing
even a
the
final
possible
conviction
bad governance
provided by the court, Mr. Speaker.
How could they upheld integrity on their part if they themselves are not good, if they themselves are not clean?
You see, Mr. Speaker, you are already judging them.
Thank you very much, first speaker for the affirmative side for your interpellation. Ladies and gentlemen, we now proceed to the second speaker from the affirmative side for the constructive speech. You have 7 minutes.
If he says he loves you and marries you, he must be faithful. But if he married you while still married to another woman, you have a problem. To our dear adjudicators, my esteemed colleagues, and my worthy opponents, it is with optimism that we face you in this debate with hopes of good health, sound mind, and the gifts of commitment. The affirmative side of the House firmly believes that it is beneficial that any person with pending criminal and administrative case be prohibited from running to public office. The status quo presents to us that it is in this current setup that persons with pending cases are allowed to run for public office. Some have even been convicted and run after being pardoned and got appointed or got elected to offices later. I would like to substantiate the claim of our first speaker that regardless of the frivolous cases to the summary procedures, regarding that, we have proposed the filing, the selection process in the COC level. The first speaker of the opposition has been singing about due process. We already answered that through the creation of the procedures of the preliminary summary upon filing of the certificate of candidacy. It pays to listen. This is why we put summary procedures first before filing of certificate of candidacy. My arguments will revolve in 2 points, ladies and gentlemen. First, by reason of public interest and security, the prohibition will save the public office from the dangers of a person who may have criminal tendencies or has truly committed an administrative offense. Second, it will save time and resources of the public offices which will be affected in case the person's guilt is proved later on. Let's proceed to my first point. We on the affirmative side aver that prohibiting any person with a pending criminal and administrative case from running in public office is beneficial as to uphold the general welfare of the people. Subordinates and office mates who will be under the office of a person with a real criminal tendency or had committed an administrative case may be put at risk if the independency of the case. If that person would obey. Yes, sir.
Yeah, I'm sorry if I may ask a question. You mentioned that it is beneficial to prevent those with criminal tendencies to run for public office.
Yes,
say for
sir.
example, I'm a good person. I'm a law-abiding citizen. I do not have any criminal tendencies. I plan to run for public office, and yet my political opponent filed a criminal case against me. Does that mean that I now have criminal tendencies because of the pending case that was filed against me?
No, we are. My point here, sir, is that you have to be clarified first. We have to make sure that you are free of any criminal or civil case, administrative case, before we allow you to run for office. We are trying to make sure that those who will be shortlisted or those who will be what do we call this, shortlisted for candidacy are free of any pending case. But you can eventually, what we are proposing here is that you can actually run once your pending case has been cleared.
Thank you, Mr. Speaker. Please proceed.
Okay,
Alright.
another question. Please
Yes,
acknowledge.
go ahead. Acknowledge.
Okay, you have mentioned about criminal, civil, and administrative case. So your stand actually is any person with criminal, civil, or administrative case cannot run in public office, not only limited to criminal case.
I'm sorry for that, ma'am. What I meant was limited to criminal and administrative cases. I did not mean to not delete the entry. I'm sorry. So what I meant was criminal and administrative case alone, for clarification's sake.
Okay, you proceed. Thank you.
Not only that does this endanger humans, it also puts at risk the public. The public office assumed
I think the second speaker from the affirmative side is he experiencing internet connectivity problems?
Yes, sir. Our sincere apologies. Our second speaker is currently experiencing technical problems.
Okay, let's wait for the second speaker for the affirmative side to return to the room. Perhaps the organizers have any input or anything to say on this matter. Okay, so let's welcome back again the second speaker for the affirmative side.
Hello, sir. Did I get cut? I'm sorry.
Yes, please proceed. Please proceed.
So as I was saying earlier, while the government is asserting an angle of probability, we invoke the maxim salus populi suprema es lex because we have to prioritize the general welfare of the people. Your Honors, I intend to point out that the state cannot neglect its duty of protecting the people from harm. Even Article 2, Section 5 of the 1987 Constitution substantiates that by stating that the state should maintain peace and order and protect the life, liberty, and property and promote the general welfare, which are essential for the enjoyment of all people of the blessings of democracy. In this democracy, in Article 2, Section 1, people are our bosses and we have to accord them the protection they deserve. Life in this argument are the people who can be under the authority of a person with pending case who might in turn be guilty of a case charged against him. Property involves the resources which may be wasted or worse abused by a person who assumes office and truly who has committed an offense charged against him. Now let me proceed to my last point, which is actually dichotomized. It will automatically destroy the problems in their onset instead of resolving them once the guilt or the decision of guilt is released. They may be viewed in the following scenarios. First scenario, it will automatically filter the list of candidates who may be in the long run yield their office if proven guilty. While it's true that yes, ma'am, recognized.
Thank you. Are you aware that in the Omnibus Election Code, under the last paragraph, that once the sentence of the final judgment has been completed, has been served, the disqualification shall be, and it says shall be lifted after the expiration of 5 years from service of sentence. Are you suggesting that this section from the Omnibus Election Code should be amended?
I am not suggesting that that should be amended. I am simply suggesting that there are procedures which we need to integrate in order to ensure due process, and that includes the filing of the procedures we have laid through the filing of the COC, ma'am.
Thank you. Carry on.
Thank you. This is not beneficial on the part of the constituents. Instead, it will hamper services if you have that kind of case, which have to be.
Mr. Chair?
Yes.
I suggest to give a few seconds or minutes upon your approval to allow the speaker, Mr. Sal, for additional time. Thank you.
Yes. Thank you very much, Honorable Attorney Nash Marumsalik, for the suggestion. Yes, with the concurrence of the other adjudicators, let's give the second speaker for the affirmative side 1 minute to finish his constructive speech.
Thank you for the consideration, ma'ams and sirs. Now, I would like to say that this is not beneficial. I mean, the situation itself needs to be addressed. Another situation is where a person with pending case runs for president of the Republic of the Philippines. What if he wins during the presidential election and
please proceed with the timekeeper. Thank you. For a few brief seconds, question to the organizers: what is our policy when it comes to internet problems?
Attorney Mac, if I may, they were instructed already prior to be in a place where internet connection is stable, among other things. So I think following the guidelines and as what has been agreed during the pre-debate conference is that we proceed with the next speaker.
All right, very well. Also, we gave sufficient consideration to the second speaker for the affirmative side. 1 minute is more than enough consideration. So
Yes,
thank you very
sir.
much. Thank you, organizers. Thank you very much, second speaker from the affirmative side. We now proceed to the second speaker from the negative side for the interpellation. You have 2 minutes. The problem is that there is no one to interpellate because the second speaker from the affirmative side isn't reconnected yet. All right, let's give it a full 2 minutes. Whether the second speaker from the affirmative side connects or not. The debaters for the affirmative side, please have care to contact your colleague to reconnect. All right, so we now proceed to the second speaker for the negative side for the constructive speech. You have 7 minutes.
Thank you, Your Honors. So before I proceed to my constructive, let me rebut some important points that were presented by the previous speakers. I believe, Your Honors, the very flaw of the entire argumentation of the entire government bends to the fact that when you run for the that when you allow a particular candidate to run is that they automatically win for that certain position, neglecting the whole idea that we have the people to actually decide whether or not to vote for them. In fact, the previous speaker told about the sovereignty of the people, that the people are actually the boss. We think they actually neglected the idea that it is not automatic for people to actually sit in and be adhered to public office when you allow them to run if they have criminal tendencies. So proceeding on constructive, Your Honors, the determination of whether or not a person is guilty shall at all times be the courts of justice to decide. Having for ourselves the convenience of judging someone and barring these persons from running for public office, who in the first place are fundamentally protected by the constitutional presumption of innocence, is as good as subjecting them to double scrutiny without due process of law. In the absence of a conviction that is final and executory, the overriding principle should be the constitutional presumption of innocence. After all, we should all be champions of democracy. Your Honors, worthy opponents, ladies and gentlemen, good morning. I have two submissions for today's debate. First, that allowing any person with pending case to run for public office accords the accused the ability to protect his dignity. And second, that the same creates a wider range and a more meaningful political participation. Onto my first submission, Your Honors, that allowing any person with pending case to run for public office accords the accused the ability to protect his dignity. In the case of Versosa versus people of the Philippines, the Supreme Court had the occasion to rule that the protection of the inherent dignity of every individual is guaranteed by no less than the Constitution. Section 11, Article 2 of the 1987 Constitution provides that the state values the dignity of every human person and guarantees full respect for human rights. A generally accepted definition of the word dignity provides that it is the right of a person to be valued and respected for their own sake and to be treated ethically. Your Honors, aside from the fact that we will be abridging the Constitution and other laws by adding pending cases as a disqualification for running for a public office, as the proposition did not propose an amendment of the Constitution as to the constitutional presumption of innocence, and as no law in the Philippines provides so, we will also be tarnishing and devaluing the inherent dignity of these persons. When you bar a person from running for public office, when that person is presumed innocent, you take the law into your own hands and you subject the same person for a second trial, a trial outside the courts of justice, without giving him the ability to prove his innocence. That way, Your Honors, you rip that person of his inherent dignity. Take, for example, the case of Senator Bong Revilla. He was charged of plunder and 16 counts of graft. Years after, he was acquitted. This is one of the reasons behind the non-disqualification of pending cases. This prevents an event where an accused who later turned out to be innocent was barred from running for public office. It would have been a blatant disregard of the power and authority and soundness of our courts of justice if Senator Bong Revilla was not allowed to run. As a consequence of his allowance to run, Your Honors, he willfully subjected himself to the will of the sovereign people on whether or not he deserves to be a senator. Clearly allowing him to run does not follow that he will automatically win. It is the call of the people whether or not to elect that person. After all, sovereignty resides in the people and all government authority emanates from them. Allowing him to run for public office despite a pending case against him is a manifestation of the valuation and protection of the state of his dignity. Especially, Your Honors, that frivolous cases can be filed as a strategy to disqualify a candidate. And on their side, they were never able to substantiate on that matter. Therefore, we humbly submit that allowing any person with pending case to run for public office accords the accused the ability to protect his dignity. As to my second submission, Your Honors, allowing any person with pending case to run for public office creates a wider range and a more meaningful political participation. Your Honors, we understand that there is no constitutional right to run for public office. Rather, it is a political privilege which depends upon the favor of the people, which favor may be occupied with reasonable conditions for the public good. In the same manner, allowing any person with pending case to run for public office creates a wider range and a more meaningful political participation. This is because when you allow any person who possesses the qualifications and none of the disqualifications, regardless of the fact that one has a pending case, you make the political arena more diverse. You encourage people to actively participate in the political process. Towards the same end, you also encourage the electorates to be critical in choosing the right candidate. On the other hand, when you limit those who can run for public office with gross disregard of the due process of law, you limit the range of political participation you expect from the people, and at the same time, you suppress the accrual of any meaningful political participation. Stated otherwise, you unreasonably limit the options of the people as who to vote, and at the same time, you discourage participation from persons who are not disqualified by law to begin with to engage in meaningful political participation. The same is enshrined in Section 16, Article 13 of the 1987 Constitution, which provides that the right of the people and their organizations to effective and reasonable participation at all levels of social, political, and economic decision-making shall not be abridged. Hence, it is no less than the Constitution that provides the right of the people to effective and reasonable participation at all levels of political decision-making shall not be abridged. As such, Your Honors, we believe that barring persons with pending case from running for public office runs afoul of the Constitution. Lastly, Your Honors, if we cannot accord basic respect and adherence to the constitutional presumption of innocence, then who are we to assert the more complicated ones? Thank you.
Thank you very much, Mr. Speaker, second speaker for the negative side. We now proceed to the interpellation by the second speaker from the affirmative side. You have 2 minutes.
Before you give me the time, your honors, may I appeal before you that I may not we not do the interpellation to be fair play, as I did not give him the fair chance to do the interpellation with me. I think that's sportsmanship.
If that is what you desire, depends on you, because it can, of course, it can affect your points, it can affect the scoring, but if you wish.
As a matter of courtesy to the time of everyone, I will yield for the interpellation.
Okay. So, in this matter, perhaps my co-adjudicators can also any input, or do we all agree on this waiving of the interpellation?
Can I speak? Can I say something, Mr. Chairman?
Yes.
Okay.
Yes, right.
Since he waived, or the second speaker of the affirmative side waived his right to interpolate, then let us give her that right. The right to interpolate includes the right not to interpolate.
Not to interpolate.
Okay.
Thank you very much, Honorable Public
Mr. Chair?
Prosecutor Grace. Yes, Attorney Nash, please.
As long as Mr. Sol, the speaker, the interpellator, is aware of the consequences of his choice, then I agree. I will allow it. Thank you.
I am fully aware, attorney. This is to compensate what I have not accorded you properly. Thank you.
Thank you. Considering that the adjudicators have a unanimous decision on this point, so the second speaker for the affirmative side's waiving of his interpellation is hereby granted. So we now proceed to the third speaker from the the third speaker from the affirmative side for the constructive speech. You have 7 minutes.
Public confidence in the integrity of the government is indispensable to faith in democracy. And when we lose faith in the system, we have lost faith in everything we fight and spend for. Ladies and gentlemen, honorable judges and fellow debaters, good morning. We have, Your Honor, we have established clearly and argued that the policy we are proposing is the better alternative to all of this, or to the better alternative to what we have now. As to the issue on innocence, Your Honor, ladies and gentlemen, until proven guilty, in our proposition, we don't negate that. We don't negate that. That is why we don't. That is why we propose that prior to disqualification, there is a summary proceeding to be conducted by the appropriate governing body to determine frivolity of administrative or criminal cases against the candidate. Section 1, Article 11 of the 1987 Philippine Constitution, Your Honors, ladies and gentlemen, states that public office is a public trust. Public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity and loyalty and efficiency, act with patriotism and justice, and lead modest lives. Our system of government continues to operate through the representatives of the people, Your Honors. Ladies and gentlemen, the public officials. The utilitarian truth of upholding the general welfare of the people through accountability, integrity, loyalty, efficiency, honesty, and service-oriented policies crafted and implemented through these public officials is beyond doubt. The plethora of Supreme Court decided cases concerning the upholding of this principle etched in the highest law of the land and its enabling statutes, such as the Omnibus Election Code, Code of Conduct and Ethical Standards for Government Officers and Employees, Anti-Plunder Law, Anti-Red Tape Act, to name a few. Logically, these laws points to the conclusion that holding public office is not merely a right, but is also a privilege, as affirmed by the gentleman from the other side a while ago. The person vying for a public post should not merely comply with statutory requirements. Yes, sir.
Thank you very much, Mr. Speaker. I'm so sorry to interrupt. I have two questions for you. First, you mentioned that your part of your motion is to allow summary proceedings to determine whether or not certain criminal or administrative cases filed against candidates are frivolous.
Yes, sir.
What is your proposal? Which governing body do you propose that will conduct these summary proceedings?
We are proposing that the Commission on Election, through their administrative adjudication, be the one who would conduct this summary proceeding.
Okay. My last question for you would be, you mentioned certain laws, including the Constitution, as basis for your motion. I remember Section 40 of the Local Government Code, which actually provides for disqualifications for candidates running for local elective public office. Are you not aware that there is actually a certain provision there that allows or that prohibits candidates that have pending cases against them from running for local elective office? There is actually that certain provision there. Are you aware of that?
Yes, Your Honor. Yes, Your Honor.
Okay.
Precisely.
Which provision would that be if you are aware?
That would be a provision under the local government code, Your Honor.
Yeah. Which provision would that be?
I am not particularly aware of the exact provision, Your Honor, but that is a provision, Your Honor, that is given in the local government code.
Okay, please proceed, Mr. Speaker. Thank you.
In a 2015 article written by Mr. Reynaldo Casas of the Philippine Daily Inquirer, he stated that our country stands out as one of the few remaining democratic countries that allow citizens with proven criminal records to run for responsible government positions or politicians inside jail cells to vie for key national or local government position. Today, Your Honor, ladies and gentlemen, an array of dark characters, convicted and accused otherwise, military leaders, murderers, kidnappers, rapists, managed to file their certificate of candidacy and their applications were accepted. It seemed, Your Honors, ladies and gentlemen, that it seemed obvious that the act of running for a public office became a numbers game instead of presenting good platforms of governance and a clear agenda to steer the country to greater heights through responsible governance. In the private sector, as an analogy, the proven business practice, especially in hiring key and strategic positions, require good persons with good character and exemplary leadership skills to take on the helm of any organization devoid of criminal records as a condition precedent, Your Honor. The reasoning is obvious. A key position in the industry that requires skill and integrity in steering the welfare of the business is practical, considering that the access or failure of the enterprise largely depended on it. Even if one may argue of the interplay of some factors outside of such sphere. The scenario is likened to a private organization, to reiterate, steered by a leader overseeing, say, 100 to 1,000 employees managing millions of investment funds, while in the government scenario, one leader oversees millions of population with billions of pesos at his discretion. In the same logic, that would lead us to believe that it is even more practical, Your Honor, ladies and gentlemen, that we need government leaders with a higher degree of integrity and sense of righteousness.
Mr. Speaker?
Yes, Your Honor.
Do you suggest that the power of the president to grant pardon and amnesty through the concurrence of the Senate be removed?
No, not necessarily, Your Honor.
How do you reconcile that? When you prevent a candidate from running because of your absolute recommendation?
Our humble proposal, Your Honor, is for the institution of a summary proceeding before the COMELEC in its administrative adjudicatory power to institute a summary proceeding to to determine whether the candidate, if he has a pending or criminal case, is entitled to allowed to be run to is allowed to entitled to run for a public office, Your Honor.
Thank you very much, third speaker from the affirmative side. We now proceed to the interpellation by the third speaker from the negative side. You have 2 minutes.
Good morning, Your Honors. Good morning, Mr. Speaker. May I now begin with my interpellation?
Yes, proceed, please.
Mr. Speaker, are you aware of the sub judice or sub judice rule?
Yes. Yes.
Okay. That means that the legal matter or controversy which is already under the jurisdiction of a court must not be talked about publicly anymore. Am I right?
Yes, yes, sir.
Therefore, you are aware that proposing a summary procedure outside the court may be violative of the sub judice rule.
No, I don't think so.
I think your team should check on that. Next question. You're proposing a summary procedure to be conducted by COMELEC to establish guilt of anyone with pending cases, thus banning the same to run for public office. Am I right?
I'm sorry, sir. I did not get your question. Please clarify.
Your team is proposing a summary procedure to be conducted by COMELEC to establish guilt of anyone with pending cases, thus banning that someone from running for public office. Am I right?
Not to establish guilt, Mr. Speaker, but to determine whether he...
I think that is what your first speaker said earlier. May I proceed with my other question? You are therefore giving COMELEC, in effect, a judicial power. Is that right?
No, Mr. Speaker. The COMELEC has adjudicatory powers on its own as to determine controversies such as these matters.
I see. So you are aware that a summary procedure of such kind is tantamount to establishing guilt in a governmental procedure? Because you said it will be conducted by COMELEC.
No, not necessarily, Your Honor. A summary proceeding of such sort does not...
But at the end of the day, we are talking about establishing guilt for someone who has a pending case, and at the end of the day, banning him or disallowing him to run for office, right?
I think your proposition is misconstrued there, because
no, it's not misconstrued, because your first speaker said that you will ban that someone to run for public office just because you have a summary procedure which will
indeed, Mr. Speaker, because the
Thank you very much, third speaker from the negative side, for the interpellation. We now proceed to the constructive speech of the third speaker from the negative side. You have 7 minutes.
To convict a criminal is an attempt to reconstruct a life. To convict an innocent, on the other hand, is a destruction of life. However, in the worst sense of a legal mistake, to disallow a rightful practice on the basis of uncertainties is oppression. Good morning, Your Honors, ladies and gentlemen. Before anything else, allow me to clarify that the affirmative side in this debate has presented to us unwarranted and derogatory assumptions that will actually result to the troubling of our Constitution, the legal frameworks of our national institutions, and worst, devalues the very principles that makes our judicial system. The affirmative side is supposed to have proved to us that, for one, there are no legal measures on disqualifications of candidates for elective posts, whether national or local, available in our legal system, thus warranting their proposition. And transcendingly, these mentioned measures for disqualifications are not enough bar as far as our legal system is concerned for the preservation of our national interest. Therefrom, Your Honors, allow me to call the attention of the affirmative side on sections 12 and 68 of the Omnibus Election Code, as well as section 40 of the Local Government Code. Both provides for the grounds for disqualification of candidates in an election. Further, Section 8 of Article 10 of the Constitution is also worth to be mentioned in here. The same is on the term limit for elective posts, such that when one is elected for president, he is no longer allowed to re-elect himself for after his 6 years term. Not to mention, in the same manner, the offenses provided for in sections 261 and 262 of the OEC, which provides for election offenses which may warrant disqualifications during elections like vote buying, Your Honors. Now, why is this important for us to mention in here, Your Honors? Your Honors, all these laws that we mentioned here and others are proofs that at place in our legal system is replete with measures that it has procedures in the instigation of a judicial proceedings that may warrant the disqualification of a candidate in an election post, proving in toto that our legal system in this issue is well entrenched so as to protect our interests and our individual rights to suffrage and the privileges accorded to us by the Constitution and our statutes. Now, Your Honors, how is it practical for us to retain the status quo and still allow any person to run for public office despite a pending case where he or she is involved? Simply, as we mentioned, we have measures. What more do we need, Your Honors? And what calls for a practical disqualification of a candidate for an elective post due to his or her being party as to a pending case? In People of the Philippines versus Zafra Marawi Makabalang, the court held that when guilt is not proven with moral certainty, it has been our policy of long standing that the presumption of innocence must be favored. And most importantly, the exoneration is granted as a matter of right. Now, Your Honors, what exoneration will still remain to a person with pending case if at the instance, even before his or her case is decided with finality, you already deduced from him a rightful practice accorded to him by our Constitution and the legal frameworks of this nation? It is as
Mr.
if saying
Speaker,
that justice... Yes, Your
Mr.
Honor.
Speaker, if I may, I'm sorry to interrupt you. I have a question.
Yes, Your
I mentioned this earlier, Section 40 of the Local Government Code, particularly subsection E. Fugitives from justice in criminal or non-political cases here or abroad are disqualified from running for local elective public office. Fugitives
Yes, Your
from
Honor.
justice in criminal or non-political cases.
Yes, Your
Is
Honor.
this not an example of the government's motion to allow or to disqualify uh, persons with pending cases from running for public office? Is this not an example of that motion?
I think the law provides it so, Your Honor, but the affirmative side of the debate is proposing a different thing. They are telling us that all criminal and administrative cases pending in court persons may not should not run for office.
Okay, my last question for
Yes,
you.
Your Honor.
Is it not that even if you disqualify persons with pending criminal cases from running for public office, is it not that the constitutional right to presumption of innocence is still preserved because that person can still prove his or her innocence in a court of law, even if he or she is disqualified from running for public office?
This House of the Debate, Your Honor, already explained to us that there is already an assumption, an unwarranted and derogatory assumption that the same is guilty of the crime out of the summary procedure that is proposed by the affirmative side. So we really cannot agree on that, on their proposition.
Yeah, please proceed, Mr. Speaker. Thank you.
Thank you, Your Honor. To disallow a person with a pending case from running for public office will only render us legal battles, as one may petition the court for allowance in his or her attempt to be part of the exercise. Not to mention that an election is always a legal battle. Not to mention that the same person is also involved in another legal battle. Are we not supposed to avoid legal conflicts, Your Honors? Furthermore, to disallow a person from running for an elective post due to a pending case of which he or she is a party is in sense impractical because it does not protect anything at all at the end of the day, Your Honors. How? Come to consider the case of Enrile when everything was hurled against the old man, but age saved him. The court provided that the current fragile state of Enrile's health presents another compelling justification for his admission to the bail. Now, how is Enrile's case connected in here, Your Honors? Simply said, Enrile's case is an illustration of a legal battle that actually yielded nothing at the end. No one was convicted, and the cases filed against Enrile were abandoned. In effect, which is that will surely happen in many cases should we allow or disallow a person with pending cases to run for elective office. To enlighten us, assume a case if filed against me and I am disallowed to run for public office. At the end, I get acquitted. What does this allowing to run to protect now that I am acquitted? Say I am convicted. What does this allowing me to run protect now that I shall be incarcerated? And in effect, I am succeeded by the next official. Simply put, the disallowance is not only shallow, but worse, futile. Thank you, Your Honors.
Thank you very much. We now proceed to the interpellation by the third speaker from the affirmative side. You have 2 minutes.
Mr. Speaker,
Yes.
are you suggesting that we value the politician who is running for the for an electoral post over the electorate in general?
Mr. Speaker, this is not a debate between whoever is a politician is.
Please
This is a
answer
debate
the
of protecting the
question, yes or
right
no, Mr. Speaker.
accorded to us by the Constitution and the legal frameworks of our nation.
No, Mr. Speaker. In fact, my question is in line with Section 1, Article 11. If you are listening and if you have read that provision in law, there is a word integrity in the embedded in that section, Section 1, Article 11 of the 1987.
I think it's very wrong
the
for us to
question is,
assume that the
Mr. Speaker,
court.
the question, Mr. Speaker, is the question is to whom we accord the protection that we are supposed to accord. The politician as an individual gunning for an electoral post, or the general welfare to which he will be serving.
That's supposed to be your problem, your side's problem in this debate, Mr. Speaker. You should have proven to us that the protection is no longer accorded to the people, but to the politician.
You are avoiding
no.
question, Mr. Speaker. I'm just asking if whether or not we should value more the right of an individual.
Mr. Speaker, whoever it is, he should be protected because there are protections that our Constitution and our legal frameworks provide.
Mr. Speaker,
and it remains whoever that person is.
Mr. Speaker, I don't think you're answering my question.
I'm answering your questions, Mr. Speaker.
Who will be, Mr. Speaker, to whom, again, to reiterate lastly, to whom we...
Again, Mr. Speaker, this is not a debate of who to protect because our Constitution protects everyone.
Precisely, Mr. Speaker, because the protection that we are proposing, the process, the procedure, the amendment that we are proposing is precisely to protect the electorate in public, the general welfare.
Mr. Speaker, it is not justice when it protects no one and when you oppress other.
Thank you very much, gentlemen, for the interpellation. We now proceed to the rebuttal speech from the affirmative side. You have 3 minutes for your rebuttal speech.
Good morning once again, Your Honors, and to the negative side. We have clearly argued that the policy we're proposing is the better alternative to what we have now. Again, to reiterate, as to issue an innocence until proven guilty, in our proposition, we don't negate this. And this is why we propose that prior disqualification be done through a summary proceeding to be conducted to determine frivolity of admin or criminal cases filed against the candidate. Of course, the negative side, Your Honors, has all the jurisprudence to cite for this is the status quo, but based on natural law, which is our Constitution and most of our laws are based, the reasonable policy to be adopted based on good reasons and standards, our propositions is more practical. Your Honors, this proposition is essential as it will give justice to people to vote and to choose officials free from doubts and bad intentions for public. This policy proposal, Your Honors, will be very necessary then to change the constitutional provisions more on the necessity of time. Lastly, Your Honors, now is the perfect time to set a pro-good governing practices deterrence to erring officials or any person who would like to use the resources of the people and of the Philippines and the immunity provided by the state to escape legal liabilities and responsibilities. This is nothing but progress. There is nothing on that proposition but progress. And that is the core intention of that proposition rather than protecting the welfare of those who have pending cases. This is to protect the general welfare of the people, to be given a good options to take better stance. And by that, allow me to end this by saying a person who is doubtful to have clean hands cannot be expected to hold public office with clean intents. Good morning, Your Honors.
Thank you very much. We now proceed to the rebuttal speech of the negative side, you have 3 minutes.
Your Honors, the team that who has the edge in this debate is the side that was able to first protect the supremacy of the Constitution by upholding the constitutional presumption of innocence, and second, the team that was able to empower the sovereign people as a vital actor in this debate, and third, the team that was able to best forward or allow any person to actively indirectly participate in the political processes. As to the first level of issue, Your Honors, we believe that the winning team in this debate is the team that was able to protect the supremacy of the Constitution. Because if we go back to their line of argumentation, they actually substituted the final and executory judgment of a court of justice by a summary proceeding of the Commission on Election. We think that even if the candidate has the chance to prove his innocence, we think that in the case of election, Your Honors, time is of the essence, especially when we argue that there are probabilities of opening of floodgates of frivolous cases just to disqualify other powerful candidates. On the other hand, ladies and gentlemen, it is very easy for the affirmative side to say that they are actually not negating the constitutional presumption of innocence. But if you look at the characterization of this person, they call them as persons with criminal tendencies, persons that who have to undergo double scrutiny without due process of law to actually prove something that they did not commit a particular act. At the same time, Your Honor, on the second level of analysis, we think that the team who will win this debate is the team that was able to empower the sovereign people. Again, I would like to reiterate that the affirmative bench totally neglects and conveniently forgets that the sovereign people is very important in this debate. However, it was also good for the second speaker to argue that they are actually doing this for the general welfare of the people, that the people are the bosses. But if you really hold on to that idea, I think we should let the people decide whether or not a particular official or a particular person actually be part was able to best allow any person for actively or directly participate in the political processes. First is that you open the floodgates. That's why it's actually contrary to the second argument of the second speaker, that it will save time and resources. Because if you establish a COMELEC for a summary proceeding and it opens the gate or floodgates for summary procedures, it actually doubles the expenses of the government. Thank you so much.
Thank you very much. And that concludes our round 2 of our Dean's Cup Intercampus Debate Tournament. If this were face-to-face, we would encourage the debaters to reach out across to each other and shake hands and congratulate one another for a job well done. So good job, MSU College of Law Gensan and MSU College of Law Marawi debaters. So organizers, may the adjudicators be given time to retire for a few minutes so that we can deliberate on the results of this debate?
Yes, sir. We will assign you a breakout room to deliberate. Thank
Alright.
you.
Thank
And
you.
just a reminder for those, Sir Rafi, go.
Okay, thank you. May I request the esteemed adjudicators to please go to the breakout room for deliberation with the presence of the one of the tabulation committee. Thank you. And may I also say that the debaters may, while waiting for the deliberation, they can have something to eat. Thank you.
All right. Thank you very much, everyone, for waiting. Yes, thank you very much for waiting as we deliberated. Before we announce the winner of round two, may I respectfully request my co-adjudicators to give their brief inputs or insights with regard to what happened sa debate. Let's start with the Honorable Public Prosecutor Mary Grace Ventura. Fiscal Grace, can we begin with you? Just a few brief inputs.
Okay, thank you very much for the opportunity, Mr. Chairman. Okay, as I've said in the breaking room earlier, let me say this cliche that know your friends, but know your enemies better. So actually the negative side, no, I appreciate the second speaker of the negative side because the stand or the argument of the second speaker of the affirmative side, especially on the democracy and the principle on the salus populi est suprema lex, no, the second speaker of the negative side used that argument against the second speaker of the affirmative side to destroy her or his argument, no. So with that, no, I really appreciate the second speaker of the negative side, of course, aside from his stance, no. Take note that in this kind of debate or in this words war, we should always take the chance that if the argument of the enemy or if the stance of the enemy, if their proposition, if we can use that against them, then it is better, especially in destroying their stance. So that's it. That's the, and also when the third speaker on the negative side, we should always prepare about the possible questions of the adjudicator, because the third speaker, as I observed it, the third speaker of the negative side, failed to argue or to answer the question of the chairman when the chairman asked a certain question or clarification to the argument of the third speaker. So we should always be ready to that. And I think these tactics on during the interpolation, when someone you interpolate when he or she tries to argue in a question answerable by yes or no, I think it is better to proceed with the next question so that the speaker cannot elaborate their stance. So I think that tactic should be learned also. So that's it. Thank you very much, Mr. Chairman.
Thank you very much, the Honorable Public Prosecutor Mary Grace Ventura, for the very valuable inputs. May I respectfully call on Attorney Nash Marhom Salik.
Good morning again. Good morning, everyone. All right, I'll make this short and sweet. Okay, a moot court, a debate. It's not only a display of your intellect, of your intelligence, of your IQ, all right? What matters more actually is your character, how you show respect to your worthy opponents, how you show respect to the adjudicators. So I think that's more lacking. So I've observed that for the affirmative, your house is the more difficult stance. Your house is the more difficult position. So in that case, you were banking on the power of the electorate and the principle of public trust. But I think you failed to fortify that fortress because you should have threaded on other grounds also. And based on the questions of the adjudicators, that became more apparent. It manifested when the questions were asked and the answers from the speakers were not direct. It was not responsive. So in that case, when we prepare for a debate, you should also foresee, you should have foresight of the possible questions. You should not be limited to your arguments. So anything may happen. And so we can also always improve on the manner on how we answer and the manner on how we treat our opponents. So always remember that because there is power in humility. And let's not equate confidence with arrogance. Always remember that, all right? And what else? For the negative side, just an observation, all right? You threaded on the presumption of innocence. And the problem with the negative side is there was a few citations. You didn't cite as much as jurisprudence. We were waiting for that citations. We were waiting for that basis, but it didn't come. All right. So if this were a beauty pageant, we had lots of abstract. You had lots of abstract reasoning. You should base your arguments on laws and jurisprudence. So there's always a room for improvement, and we appreciated your efforts. And we would like to congratulate the House of the Affirmative and the House of the Negative. And you did a good job. And we wish to see more from you and hear from you. So congratulations.
Thank you very much, Attorney Nash, for your valuable inputs and comments. And considering that Attorney Nash dealt on the negative side, I would also like to share a little bit about the affirmative side. So, in my opinion, the affirmative side failed to establish your foundation. Now, the policy is there. Your intention is clear, but for me personally, it's the foundation is not that strong or not that well laid or not that well built. No, and unfortunately, the affirmative side has the burden of proving your side, and this is particularly because the motion will require an amendment or change to a lot of our laws, including the Constitution, the Omnibus Election Code, the Local Government Code, even the COMELEC. It's a good point that you pressed that for the COMELEC to have a jurisdiction to hear special proceedings, whether or not cases filed are frivolous or not. No, so you could have probably built your foundation on this. No, explored this, how the COMELEC's jurisdiction will work concurrently, probably with the existing courts of law. No, and also with what Fiscal Grace and Attorney Nash mentioned, that always remember, ladies and gentlemen, to treat your opponents with courtesy. So although we understand no, na because of the height of your emotions, probably your overexcitement, your anxiety, no, na it all builds up at the time of the interpellation. The interpellator hasn't yet finished the question, you already answered. No, so we understand if it's in the height of emotions, but for round 3 and for the finals, we encourage the debaters to allow your interpellator to finish the question first and then answer properly. if for the interpellator, ask questions that are clear, and if your thoughts are confused, reform your question so that your opponent can also answer properly. And lastly, we encourage the debaters no na do not be afraid to explore, no, because we understand also your limitations as law students, no, but this is the point of debate. We open our minds. So I think this is where we, the adjudicators, saw how limited the level of discussion was. Medyo na limited siya. So when you encounter issues like these, ladies and gentlemen, do not be afraid to explore and ask questions, which will lead you to more research, so that your minds will be broadened, and then your level of debate will improve. No, so do not be afraid to go beyond your limitations. No, you probably say, I'm limited, I do not know procedure, I do not know jurisdiction, I'm so limited with this. No, pero do not be afraid to explore. You have to do research. No, and with that said, ladies and gentlemen, as the chairman of the panel of adjudicators, it is my privilege to announce the winners of round 2 of our Dean's Cup tournament by an average margin of 5.6. And with a unanimous decision, we declare the winner to be the negative side of the house, and that is MSU Marawi. Congratulations for winning round 2, and we declare by a unanimous decision also the best speaker to be the second speaker from the negative side, Mr. Nurhalim S. Karim. Congratulations. And there you have it, ladies and gentlemen. Thank you very much. And thank you very much, Honorable Public Prosecutor Mary Grace Ventura, Honorable Attorney Nash, Morom Salik, our distinguished panel of adjudicators. Thank you very much. Good job, debaters. Good job. We now turn over the virtual floor to the organizers. Thank you.
Thank you so much, sir and ma'am.
Permission to leave, if we may. May the
Yes po.
adjudicators will. Thank you.
I'll
Thank you
see
very
you
much.
this afternoon. Thank you.
Thank you. Thank you.
May I call on the MC to facilitate for our third rounds of this year's Dean's Cup, the Intercampus Debate Tournament.
Okay, thank you, Ma'am Charity. May I call on again our SLSC President, Mr. Fritz Ronald Amparado, to introduce to us our our adjudicators for the third round this afternoon. Thank you.
Thank you, Sir Rafi. So we are on our final round for the eliminations for this 2021 Dean's Cup, the Intercampus Debate Tournament. Our adjudicator for Panel C, the first adjudicator and the chief adjudicator, I believe I was able to introduce her, but let me just reintroduce her and her name also. So our third adjudicator and the first adjudicator and the chief adjudicator of the third round is none other than, let us give her a resounding and a round of applause to Prosecutor Mary Grace Ventura. A round of applause and RTX. Thank you, Prosec. For our second adjudicator, he is a graduate of Bachelor of Arts in English at Mindanao State University, Marawi City. He is also a graduate of stenography at Santa Monica Institute of Technology, Iligan City, year 2012. And he earned his Bachelor of Laws at University of the East Manila way back 2014. He is a licensed real estate broker and a member of the Philippine Sharia Bar. And he was admitted a member of the Philippine Bar way back 2017. He's currently the Provincial Attorney for and now designated as Assistant Provincial Legal Officer, Legal Services, Provincial Government of Lanao del Sur, 2017 up to present. He is a lecturer of the MSU College of Law, Marawi and Iligan campuses from 2017 up to present. He's a partner at Mac Law Offices Marawi City in a lecturer and special lecturer of MSU Sharia Center and National Commission on Muslim Filipino. He assumes responsibility, meets objectives, and aim at accomplishing tasks timely and efficiently. Ladies and gentlemen, our second adjudicator, my idol, help me welcome and give him a resounding virtual round of applause to Attorney Faisal Kali. And our third adjudicator, I believe I already introduced him. He's one of the adjudicators on the first round. But again, let me reintroduce him. Our third adjudicator is none other than Attorney Leonard Mann. Let's give him a virtual round of applause and heart reacts. Thank you, Sir Rafi.
Okay, thank you, Press. May I now call on the chair for the third round? Sir, I'll give you the floor.
Prosec Ventura.
Hello? Yes, hello?
Yes po, you may now
Okay.
preside the third round po.
Okay, so may I now call this house into order, and I call the debaters. On the affirmative side, we have ano bang sa affirmative side? Is it MSU Iligan? Yes. And on the negative side, MSU Marawi. So the debaters on the affirmative side, MSU Iligan, the first speaker, Abdul Khalif P. Amindato. The second speaker, Rohanima Guru. And the third speaker, Aknida D. Mamakutaw. On the negative side, MSU Marawi, the first speaker, Abdul Hata Biderico. The second speaker, Norhalim S. Karim. And the third speaker, Muhammad Ayman S. Langlang. Okay, so they will debate on the motion the president can run for the vice president. Okay, so may I now call this house into order and call the debaters. Hello?
Affirmative side, I think you may now be.
Absoluta sententia expository non indigent. When language of law is clear, no explanation of it is required. You're required to further advance the explanation. Your Honor, Article 7, Section 4 provides that the President and the Vice President shall be elected by direct vote of the people for a term of 6 years, which shall begin at noon on the 30th day of June next following the day of the election, and shall end at noon of the same day, 6 years after. Further, the president shall not be eligible for any re-election. No person who has succeeded as a president and has served as such for more than 4 years shall be qualified for election to the same office at any time, Your Honor. Your affirmative will debate in this in two levels. Number one is how do we best interpret the law or the provision, and second of all, how do we best encourage or how do we give value to the participation of the people by giving them the chances to select whoever they for as long as they are qualified in that position, Your Honor. The first thing that I would bring in this debate is the principle of verbal liges. That is where, whenever possible, the words used in the Constitution must be given their ordinary meaning, except where technical terms are employed. Thus, in the GM Tuason Corporation versus Land Tenure Administration, the court speaking through Chief Justice Enrique Fernando declared that we look at the language of the document. We look at the language of the document itself in our search for its meaning. We do not, of course, stop there, but that is where we begin. It is to assume that words in which constitutional provisions are couched express the objective sought to be attained. They are to be given their ordinary meaning, except where technical terms are employed, in which case the significance thus attached to them prevails. As the Constitution is not primarily a lawyer's document, it is being essential for the rule of law to obtain that it should ever be present in people's consciousness. Its language, as much as possible, should be understood in the sense they have in common use. What it says according to the text of the provision to be construed compels acceptance and negates the power of the courts to alter it, based on the postulate that the framers of the people mean what they say. Thus, these cases where the need for the construction is reduced to a minimum is further propounded in the case of Francisco versus House of Representatives. Your Honor, we would argue that in order for us to best interpret the law, number one, we must first look at the ordinary meaning of the statutory text. Then we look at the broader statutory text afterwards. Purposivists and textualists would agree that there's no need for us to overcomplicate the translation or even the meaning of every words or phrases in the Constitution. For as long as it is clear and loud, there's no need for us to give another meaning of it. Second of all, Your Honor, there's no way that we should be debating under people's opinion or under people's own interpretation of the law. It is clear in the Article 7, Section 4 of the 1987 Constitution that what we mean by re-election is allowing the president to be re-elected as a president. But this is not the case, ladies and gentlemen. On the motion, we're telling you that we need to be able to allow the president to run as a vice president because he is qualified, and this way we could be able to give our people the chance to choose whoever is the candidate they prefer for that position or for that office. Simply because the president, for example, is qualified to run as a vice president. Yes.
So, do you agree with me that the president, by running for vice president, there is this possibility that after winning for vice president, he or she can succeed to the presidency?
Yes, Your Honor, we agree to that one. But that is not the case of re-election, Your Honor, because in our situation here, we're debating about re-election, or we're debating about allowing the president to run for vice president to begin with. And if we're going to allow that to happen, it's the choice will be left to the vast majority or to the electorates. They would have to vote if they think that this president running to vice presidency is qualified or is suited for the position. Then we're going to allow him, and if he wins, he wins. But on yes.
Will that not be a circumvention in contravention of this legal maxim? Quando aliquid prohibitur ex directo prohibitur et per obliquum. You cannot do indirectly what you cannot do directly.
We submit to that, Your Honor, but we will also argue that that is not what is meant by our proposal. That when we allow the president to run for the vice presidency, it does not necessarily equate to him with assuming the position of being president again. to begin with. But let me proceed with my argument. On our model, we want to let the decision to come from the vast majority or to the electorate, because in the case of Diocese of Bacolod versus Commission on Elections and the election officers of Bacolod, Justice Leonin propounded that the Philippines is a democratic and republican state. Sovereignty resides on the people and government authority emanates from them. That's according to Article 2 of Section 1 of the 1987 Constitution.
Okay, so may we now call the first speaker on the negative side for his or her interpellation.
Once again, good morning, Your Honors and members of this most imposing congregation. First question, Mr. Speaker. Counsel, you've mentioned that verbally his principle is the best way to interpret the Constitution, correct?
Yes.
But isn't it
one of
better?
the ways.
My time, Mr. Counsel. But isn't it better to interpret the Constitution as a whole in its interrelation with the other provisions of the Constitution?
I stated that earlier
Yes.
as I read the Section 4 of Article 7 of the
Yes, but will
1987
you agree with me that it is better to interpret the law or the Constitution in its totality or as a whole instead of focusing on a certain provision in the Constitution?
Yes, Counsel. Yes.
Second question, Mr. Counsel, will you agree with me that this setup or your proposal deprives other from equal opportunities, Mr. Speaker?
No, I disagree.
Yes, because this is because the sitting president is actually advantageous in comparison with other candidates vying for the position of vice presidency.
I don't
Next
understand what
question,
made you say that.
don't you think this election of president for vice presidency is also unfair?
No, I don't
Yes.
think so.
Yes, it is unfair because actually the sitting president is with the advantage of running for the vice presidency. Hence, it is
If we
important to
allow
ban
him to
him.
run for the vice presidency, he will
Next
still have
question,
a
Mr.
worthy
Speaker.
opponent.
Since the president
Would give him
after
a
his
fair
term,
fight.
Mr. Speaker, my time, don't you think your proposition is according as mentioned by Attorney Mann, don't you think your proposition is a circumnavigation of the law or the Constitution?
No, not
Yes,
exactly.
because this is since the president after his term from being the president of the country may flee from any criminal accountability by running for vice presidency.
No, that's not gonna happen, because even if he
No more
wins for the
questions,
vice
Your
presidency, he will
Honors.
still be accountable for the crimes he has committed beforehand, and we can still hold him accountable for that.
Thank you. No more questions.
Okay, so may we
We'll
now
go-
have the first speaker on the negative side to speak about the necessity of the resolution that president can run for vice president. So the first speaker, negative side, you may have the virtual floor.
Yes, thank you, Madam Chair. Your Honors, the beauty of a democratic government is the concept that sovereignty resides to the people, by the people, and for the people. But what happens then when people, through their constitution, allows a sitting president to be elected for vice president? Granting without conceding that there is no express provision prohibiting the election of the president for vice presidency, what we need to take a closer look into this debate is on the inimical effects of this election and how is it necessary, beneficial, and practicable to prohibit the same. And this is because this is a first impression debate. It is up to the Supreme Court to decide on whether or not a president may be allowed to run for vice presidency. Your Honors, fellow debaters, members of this most imposing congregation, once again, good morning. Allow me to present my 2 points of argumentation proving the necessity of banning a sitting president to run for vice president. First, the president cannot run for vice president as this will devalue, in essence, and use the term limit set in the Constitution for the candidates. And second, this is to prevent any use of possible manipulation in the conduct of election for vice presidency, while at the same time he is sitting as an incumbent president. On my first argument, Your Honors, what do we mean by term limits and why is it enshrined in the Constitution? Ladies and gentlemen, term limits acts as a method of curbing the potential for monopoly where a leader effectively becomes president for life. This is intended to protect a republic from becoming a de facto dictatorship. In the case of the Philippines, for instance, the case of Marcos is one but a necessary example to illustrate how term limits are important and very significant. Being in power for approximately 20 years as the longest serving president of the country, Marcos had been involved in several corrupt practices, including the suppression of democratic processes during his lifetime. All of these corruptions were made possible or committed because Marcos was in power for a very long period of time. Therefore, it is necessary that the president cannot run for vice presidency to prevent another dictatorial form of government to occur once again. That is the very essence and use of term limits so as to provide a curb once again on potential monopoly of power by the sitting president once elected as a vice president. The affirmative side, or this is the wisdom behind...
Mr. Speaker, is
Yes.
there any express prohibition for the president to run for vice president in the Constitution?
We concede and we agree that there is no express provision in the Constitution banning the president from running for vice presidency. But we believe that this is to be settled by the Supreme Court and is therefore should not be the focus of this debate, because this will be a very thin debate if we argue on said provision.
Next question, Mr. Speaker, is do you
Yes,
agree?
Counsel.
Do you agree that in a democracy, the will of the electorate should be the paramount law?
Yes, Counsel. The will of the majority or other people is the sovereign power in a democratic society. But I do agree that the people should be given equal opportunity, or the candidates should be given equal opportunities and chance to be elected by the majority. And since the sitting president is more advantageous because he is the incumbent president and running for vice presidency, then he is advantageous compared to other candidates vying for vice presidency.
Thank you, Mr. Speaker.
If I may proceed, Mr. Counsel, this is the wisdom behind term limits and why it is enshrined in the Constitution. This ultimately limits the exercise of power of a public officer once his term of office comes to an end. The affirmative side may argue that the election for vice president and not for election. The affirmative side may argue again that the election is for vice president and not for the re-election to being president once again. I believe that they are essentially the same, Mr. Speaker. The fact that the vice presidential position is the second highest position in the land is a red flag for us to worry that the sitting president is eyeing the vice presidency to extend his term in the office and circumnavigate the term limits set by the Constitution. Hence, to prevent this inimical effect, it is very necessary to ban a president to run for vice presidency. This leads me to my second argumentation, which is to prevent any possible manipulation in the conduct of the election for vice president, while at the same time the sitting president sitting as an incumbent president. What are these manipulations and corruption, ladies and gentlemen? Ladies and gentlemen, when a sitting president runs for vice presidency, there are several issues that may occur and can be committed by the latter, including but not limited to undue influence, for instance, abuse of power and the use of governmental funds to fund his election for vice presidency. Imelda Marcos, for instance, was convicted of several corrupt-related cases, including ownership of ill-gotten wealth. And these were all possible because his husband was in power as the president at the time. They literally abused their power and manipulated several
Mr.
laws,
Speaker,
including the use
Mr.
of
Speaker,
governmental funds.
Mr.
Yes,
Speaker,
Counsel.
how
Yes,
sure
Mr.
are
President.
you? How sure are you that all those allegations will prosper if a president runs for vice president? How sure are you that the president will use its influence? Please proceed.
I believe it happened, ladies and gentlemen, because the case of Imelda Marcos was convicted in 2018 with several corruption-related practices at the same time owning ill-gotten wealth, Mr. Chair. So furthermore, they literally abused their power and manipulated several laws, including the use of governmental funds for their own benefit and interest. In consonance to this, it is a must to prevent one from possibly using public funds and resources in order to come in power once again as a vice president and flee from charges once his term as president comes to an end. In the end, what we on the negative side is aiming to prevent is the use of the vice presidency position as means for the president to circumnavigate the term limits set by the law and the constitution in general, and being the instrument to achieve self-interest. With this, we stand against the running of a sitting president for vice presidency. Thank you.
Okay, thank you so much, first speaker, Mr. Abdul Derico. So may we now call the first speaker of the affirmative, Abdul Khalif Amindato, for his interpellation. Okay, you may now start your interpellation, Mr. Amindato.
Good morning, Council. I would appreciate you answering yes or no.
Yes, good morning. Sorry.
Okay, first question. Do you agree that allowing the president to run for vice president is not equal to having him as the direct winner of the vice presidency?
I agree, but exactly the point of Sir
Yes,
Attorney
thank you
Mann
for that one.
mentioned.
Thank you for agreeing. Second question, your counsel. You understand that the Constitution are primarily worded by the framers in a sense that is understandable in its simple meaning.
But as I have mentioned a while ago, it is
Yes or
important
no,
to take a look at the Constitution as a whole.
Yes or no, counsel, please.
Yes, but it is important
All
to
right,
take a look
thank
at
you
the
so much.
Constitution as a
Let's
whole.
proceed to the third question. Do you find Article 7, Counsel, please, this is my time. Do you find Article 7, Section 4 ambiguous?
No, but exactly the point. No?
Thank you so much. Let's proceed to the fourth question. Do you think that in democracy, it is not, do you think that it's still democracy when we limit the choices of the people?
Come again, Mr. Speaker, you were choppy.
Let me repeat it. Do you think that it is still democracy when we're limiting the choices or options of the people?
Not necessarily. No, we're not limiting the choices of the people. In fact, we are actually giving opportunities, equal opportunities to other candidates vying for the same
Have you
position.
heard of the case of Diocese versus Commission on Elections?
Yes, and what about it, Council?
All right. So let me just further enlighten you with that, because according to Justice Leonen, all government authority emanates from the people and no unreasonable restrictions of fundamental and preferred
I understand. What's your question, Council?
Of the electorate during political contest, no matter how seemingly benign, will be tolerated.
Yes,
you understand
and?
that, right? All right. No further question, Your Honor.
Okay, thank you so much. Debater Abdul Khalif Amindato and debater Abdul Derico. So may we now proceed to the second speaker on the affirmative side to talk on the beneficiality of their stand, Ms. Rohanima Guro. So you may have the virtual floor.
Your Honors, I will start with more legal basis and proceed with the analysis for both sides. We think the negative side has displayed a very myopic view of what democracy means. It's unfortunate to hear from them to argue from a perspective that violates the tenets of a democratic state like the separation of power and presumption of innocence. Few clarification. If then president runs for vice presidency and by some mere circumstance or conspiracy theories, he's suddenly elevated to becoming a president, we think this is a possibility that should not be considered, especially because this kind of conspiracy theories is not irrelevant in determining whether or not who should be able to run or not. First they argued that this deprives equal opportunity. We think that this argument works under the presumption that the candidate will automatically win, which is speculative by nature. It is not for the COMELEC to decide who will win or not, but for the people. And it's not like allowing the president to run for vice presidency means that other people are not allowed to run. So we believe there is a logical leap in this argument because if any, it is the negative side who is depriving equal opportunity because they're already filtering who can run and who cannot. Second, they argued that there will be abuse of funds and all of this kind of conspiracy theories. Again, we think this is a presumption. And even in any other public offices, any public possession is susceptible to abuse. But it doesn't mean that we should deprive people to actually aim for that possession just because we suddenly decided that they are guilty of something. Even when they argued about Marcos, we think that even Marcos was ousted because of our democratic rights, which is the right to protest. So this means this is a manifestation that democracy self-corrects. So there is no need to filter necessarily or amend the constitutionally based rights for people to run for vice presidency. The moment we politicize constitutional liberties just because we do not prefer the current political climate will be the ultimate death of democracy. We aver, Your Honors, that the vision of the negative side, which is ultimately to change the standards of qualification for vice presidency, is a deliberate attempt to circumvent the law to serve temporary feelings of dissatisfaction from this administration. In fact, under Article 7, Section 3 of the Constitution, it states that a vice president candidate must be a natural-born citizen, a registered voter, able to read and write, and among others. There is no mention of a requirement that says that a person running for vice president should not be a former president or necessarily should be of, free from any cases that are that's not adhere to our values. So the wisdom behind why the qualification for public office is so broad is because the framers of the Constitution insist on having a state that is impartial and blind from the natural disposition of people who wish to serve the country. In fact, even in the rules of procedure, declaring a candidate a nuisance candidate requires very rigorous filing of petition because it is a constitutional mandate to, as much as possible, reject a selective admission of candidacy in elections. In the case of Gonzales, yes,
Ms. Speaker, what is the rationale of the prohibition for the president to run again for the same office?
The prohibition, sir, necessarily is acquiring the Constitution because we don't want monopoly of power. But it's different from being able to run for vice presidency because the function of the vice presidency is very different from the president. And ultimately, there are no executive privileges granted to the vice president. So I would like to proceed with the case of Gonzales versus Comelec.
Before that, Ms. Speaker, another question last. Are you aware of the golden rule of construction that courts may depart from the normal or literal meaning of a word where it bears an absurd result? I repeat, the golden rule of construction that courts may depart from the normal or literal meaning of a word where it bears an absurd result. How will you now reconcile this rule of construction, which is the golden rule of construction, to the prohibition?
I humbly submit, Your Honor, that this golden rule necessarily also is in contrast with the rule that there should be a presumption of constitutionality for our policy because in nature, the re-election term in the Constitution does not necessarily prohibit re-election for vice presidency. So under the same statutory construction, we also aver that re-election means you should not be re-elected to the same position that you vacated, which is not vice presidency, but presidency. So in the case of Gonzales versus Comelec, the court held that the genuine democracy thrives only where the power and right of the people to elect the men to whom they would entrust the privilege to run the affairs of the state exist. So in the language of the Declaration of Principles of our Constitution, we already said that the Philippines is a republican state and the sovereignty resides in the people and all government authority emanates from them. We think this is important because the reason why there is a very high bar in terms of really limiting the ability of people to participate in election is because the Constitution wants a democracy wherein the citizens' right to freely participate in the exchange of ideas in the furtherance of political decision making is recognized. So it deserves the highest protection of the court that may provide. And because public participation in nation building is a fundamental principle in our Constitution. So we also would like to aver under the resolution of number 7.
Ms. Speaker, how do yes, for the court, please. There is an issue on the possible circumvention of the policy on the prohibition for the election by way of buying the vice president and then vacating the president. How do you now ensure the what do you think are the safeguards, no, to ensure that this prohibition is still observed within the bounds of your motion? Thank you.
Thank you for that very good question, sir. This also allows us to clarify that even if in the worst case scenario, the president is elected to the vice presidency and he indeed abused funds and his power, we think that there are still other alternative remedies that are existing in status quo. Like, for example, the idea of impeaching this kind of public officials. So these kinds of remedies exist because they are remedial in nature, but it doesn't mean that we should automatically assume that prior to election, these people are already guilty of abuse of funds and power. We think this is a power that is necessarily safeguarded and exclusive to the Supreme Court and should not be intervened by the COMELEC. We believe
Notwithstanding that, Speaker, notwithstanding the remedy you have mentioned, is it not that not in all times you can impeach an individual who ran for vice president then towards president? There is still that circumvention, is it not?
Yes po, that is possible po. In fact, any democratic process is actually very rigorous. So if impeachment is so difficult, it only means that there is so much burden to prove someone's liability of a certain crime. So which also necessarily contradicts the idea that we shouldn't judge judge people of guilty of being of abusing a certain power that they have never assumed in the.
Okay, thank you so much, second speaker on the affirmative side. May we now call on the debater Nurhalim S. Karim for his interpellation.
Good afternoon, Ms. Speaker.
Good afternoon, Council.
You may continue for your interpellation, Mr. Nurhalim S. Karim.
Okay, so yes, Your Honor. Shall I proceed? Okay, so first question, Ms. Speaker. Would you agree with me if I say that 6 years is fair enough for a president to serve?
If that's what the Constitution allows, then it is fair.
Okay,
Yes.
thank you. Second, isn't it that by virtue of mandatory succession in cases provided by law, the vice president shall take over the position of the president?
Yes, I agree.
Thank you. Do you agree that there is a reason behind the term limits?
Yes.
Okay. Would you agree with me if I say that allowing the president to run for vice president might be an avenue for collusion and abuse of power, especially when the president is an ally of the vice president?
Might be is a very speculative term in court, Your Honor.
Okay, so would you agree with me if I say that there is no harmonious and singular rule in the application of statutory construction?
Yes.
Especially in cases
itself, which
Yes.
is re-election.
Yes, especially in cases when the Supreme Court deviated from the previous ruling and served the interests of justice. Okay, Ms. Speaker, would you agree with me if I say that democracy is not absolute?
Yes.
Okay, so are you aware of what happened during the dictatorship of Marcos?
Yes. And he was
Okay.
ousted because of our right to protest.
And how many years did it take before he was ousted?
Enlighten me, Your Honor.
Okay, so you do not know that. Follow-up question. Do you know how many people lives were actually lost during the people power?
Yes, but that's a misleading example, Your Honor.
Okay, so next, if we talk about safeguards, what are your do you believe if we say that our proposition is actually providing safeguards where on your side there is none?
No,
Okay. Your time is up. Can we now proceed to the second speaker on the negative side, the debater, Halim S. Karim? Okay, you may have the virtual floor.
Thank you, Your Honor. Ladies and gentlemen, before I proceed to my constructive, let me rebut some of the points presented by the affirmative side. I think if you may have observed, there is a glaring disparity in disjunct between the argumentation of the first and second speaker. Because in the interpellation of the first speaker, he argued that democracy is not democracy if it is limited. He actually said that democracy should not be limited. However, in the second speaker, she actually conceded that there are filtering mechanisms. In fact, there are qualifications set by the law for the people who can actually run. We say, and we would like to aver that absolute is not democracy. The second speaker agreed on that earlier. And we will forward later on in my constructive why it is essential to recognize that democracy is not at all times absolute. Next, we would like to aver on the principle of the singular application of the interpretation of the law, which is the plain meaning rule. We say that there are plethora of cases ruled by the Supreme Court where the Supreme Court ruled and deviated away from the precedents and actually ruled in the interest of justice. That's why it's very important when one of the esteemed judges pointed that there is that okay, so proceeding on, we think that democracy is not absolute in a specific sense. So we proceed to the argument, the speech proper. When the Constitution speaks of any position in the public service, Your Honors, from the local positions up to the national positions, the Constitution speaks of a term limit. In fact, term limits are edged in law. So when you allow a president to run for vice president, which is aggravated by reason of the mandatory succession of the vice president to the president, you circumvent the law and transgress the fundamental principle of the law of the land on the limitation of terms of office. Your Honors, worthy opponents, ladies and gentlemen, good morning. I have two submissions for today's debate. First, that when the president cannot run for vice president, it provides equal access to opportunities for the vice presidency. And second, that the same inability can pave way to institutional reforms and open up the political system. Onto my first submission, Your Honors, that when the president cannot run for vice president, it will provide equal access to opportunities for the vice presidency. Your Honors, the presidency is the highest position of the land in public service. And when one becomes a president, it entails a massive system and amount of popular support to get there and to stay there. When the president can run for vice president, you discourage potential candidates from running for the vice presidency. And even if they push through with
Counsel, how do you distinguish? You talk about equality. How do you distinguish the situation in this proposition with that of the situation wherein the former president GMA ran as member of the House of Congress? When you talk about the opportunity to also be opportunity to become congressman and vis-a-vis the opportunity to become a vice president. Proceed, Counsel.
Yes, Your Honor. Thank you for that question. I think the determining factor really is as to the nature of the office and the possibility of mandatory succession. Because when we talk about the case of GMA, she has no line of succession to the place of the president. Where in this case, we are actually talking about the circumvention of the law and actually running afoul of the rationale behind the prohibition of term limits, Your Honor. So if I may proceed.
Counsel, my second question, is it not that a Speaker of the House of Congress is the fourth in line to the presidency? And you talk about circumvention, is it not also possible that the Speaker to become the president? Please proceed.
Yes, Your Honor. But if we talk about probability, as we are talking about really here in this debate, the problem lies with the vice president succeeding to the president. And if we talk about chances, there is more chance in terms of the vice president succeeding to the president instead in the case of GMA, Your Honor. So if I may proceed. So when the president can run for vice president, you discourage potential candidates from running for the vice presidency. And even if they push through with their candidacy, Your Honor, you place them at a huge disadvantage for running against the president, who obviously have all the political, social, and financial support he needs to secure the vice presidency. The problem is you create a situation where someone who is already entrenched with the political climate and terrain, who obviously have the springboard and leverage to campaign for himself with a complete campaign for himself to compete with a challenger. Remember that when a president vies for presidency, Your Honor, it's like vying again for the presidency, as the two positions both require a rigorous and complex system of campaigning. So what are the possible scenarios or repercussions when a president runs for vice president? One, a president seeking the vice presidency is vulnerable of constant political pressures from those who support. He must preserve and has to devote his time. Yes,
Mr.
Your Honor.
Speaker, Mr. Speaker, we are not talking here about probabilities, but the legality of the act, which is the subject matter of the proposition. My question is there any ambiguity as to the prohibition of the president to run for re-election? Again,
Yes,
is there
Your
any
Honor.
ambiguity as to the prohibition for the president to run for re-election?
Yes, Your Honor. Because if we look at the Constitution, the use of the word any after the words president and vice president refers actually to the probability of a certain of the president running either for the both position, Your Honor. So we think that if we allow the president to run as a vice president, there is actually an ambiguity because the Constitution does not provide exactly as whether or not it refers to the president or to the vice president because of the use of the word any in the Constitution, Your Honor.
So it is your legal position, Mr. Speaker, that the word any pertains to the position and not to the fact of re-election? Is that what you're saying?
Yes, Your Honor. It is my
Thank you,
position.
Mr. Speaker.
Thank you, Your Honor.
Okay, thank you so much, second speaker on the negative side. So may I now call the second speaker on the affirmative side, Ruhanima Guro, for his interpellation. Okay, you may now proceed for your interpellation, Ruhanima Guro.
Yes po. Hello, Your Honor. Okay, I will start with my question. Mr. Speaker, you said that our policy will be disadvantageous because the former president already has financial and political fundings, right? Yes or no?
Yes.
Yes. So you are saying, and evidently, that every rich person should be banned from running for a public position because they have a financial advantage. Yes or no?
Not necessarily. If you look at the nature of the presidency, that is not the case, Ms. Speaker.
Thank you for your answer. So you are also saying that this disadvantage is based on the possibility of them winning. So are you right? Am I right? Yes or no?
Yes.
So there is no operative definition of what is advantages and disadvantages in elections. Yes or no?
Yes.
So you agree that your new restriction is based on feelings and speculations, right? Yes or no?
Not necessarily.
So I would also like to ask that, are you aware of the idea of presumption of the principle of presumption of innocence? Yes or no?
Yes.
So you agree that in your model, you are already presuming that the potential candidate is already guilty of abusing funds and powers? Yes or no?
It happened before. That's why we need a safeguard.
No further question, Your Honor.
Okay, thank you so much. May we now proceed to the third speaker of the affirmative side, Ms. Ahmida D. Mamakota. You may have the floor.
Hello, ladies and gentlemen, Your Honors, good morning. In a case decided by the Court of Appeals Special 8th Division with Judge Bruce Celas as the ponente, he said that a man may be denied his right at the mere whim of government is the anathema to democracy if the ideal that indeed freedom prevails in our land is to be upheld. Ladies and gentlemen, as what my previous speakers have already told you, the law is very clear. There is no express prohibition to allow a president to run as vice president. MSU Marawi's fears in this debate are clearly misplaced because they bank on all their arguments on mere possibilities and potential happenings that can or cannot happen. Whereas in our side and in our model, we uphold what it really means to have a democratic institution and country at that. For the purposes of this debate, however, let's just engage in their argument, right? Allowing a president to run for the second highest position of the land should not be seen as merely the president circumventing the law and exempting himself from both civil and criminal liability. This view is not only oversimplistic, but is really presumptuous. This is really problematic in light of the new conditions we are facing right now. In reality, the president's plan to run for vice presidency under scrutiny today, it's just really a conspiracy theory that does not really merit the changing of the very language of our constitution, which is the primordial law of our land. But before I proceed to my constructive, I would like to first rebut the cases presented by the opposite side. First, they said that by allowing the president to run for vice president, we're simply allowing him to circumvent the law and exempting himself from liability. We disagree because no one is indispensable to answer for his actions. Even the president although he enjoys the state immunity, may even be sued and be impeached and be removed from office. But further, let's argue that although these people have means and capacities and financial capabilities to overthrow all other candidates for the vice presidency, that is the very call of democracy. That is why we give the people or the electorate the power to choose who their leaders should be. Secondly, the equal access to all. They merely say that if we allow the president to run for vice presidency, it would be unfair to all the other candidates. But can't you see, in a nutshell, they are trying to do what they're trying to prevent. Because what they're trying to do is to limit the choices of the very electorate that they are trying to uphold their right to vote. Thirdly, they already promote the idea that the Supreme Court have the capacity to overthrow the language of the Constitution and clearly prohibit the president for running for vice presidency. We submit, Your Honors, that this would be prohibitive of the separation of powers when clearly the language of the law is very clear. This means that absent any ambiguity, there is no jurisdiction of the Supreme Courts to intervene and say or interpret the law, which is already very clear. Now let's proceed to my constructive. We argue that it is practical to allow the president to run for vice presidency because number one, it is in line with democracy. Number two, prohibiting him will just run counter.
Speaker, so is it your legal position that this proposition, whether or not the president can run for vice president, a political question, not a justiciable question?
As of now, yes, sir, because the language of the law is very clear, and the only thing left to do is to apply the law itself.
So the Supreme Court cannot entertain any petition, if ever in the future one will be filed, precisely raising or assailing this kind of action.
Since any present position right now, Your Honor, we cannot really assume that the Supreme Court have the authority to answer for a political question. So right now, as it remains, it's still a political question which the Supreme Court cannot intervene.
Thank you, Mr. Speaker. You may proceed.
Okay. Secondly, prohibiting the president to run for vice presidency will really just run counter to the constitutionally protected rights of the right to vote and the right to be voted for. And lastly, no one is really indispensable in running the affairs of a country. Number one, allowing the president to run is really practical because not only do we uphold the very essence of democracy, but we increase the political participation. As we have seen in the 2019 elections, only 75.90% of the entire electorate was able to vote. However, when we promote a policy encouraging or empowering the very power of this electorate, we try to encourage the idea of them participating in the very elections that we are trying to have. Also, in the case of Tolentino versus Comelec and De Castro versus Comelec, the court held that in exercising its powers and jurisdictions as defined by its mandate to protect the integrity of elections, the Comelec must not be straitjacketed by procedural rules in resolving election disputes. In the same manner, they cannot simply be directed and be able to arbitrate who deserves to run and who does not. Second argument, this prohibition will just run counter to the constitutionally protected rights, which is the right to vote and the right to be voted for. As enshrined in Article 2, Section 26, the state shall guarantee equal access to opportunities for public service. Disqualifying the president is already tantamount to vesting the powers to choose on the COMELEC and in effect violates the same political power of every single member of the electorate, because it's as if we're already arbitrating that this person is disqualified and he is not able to run for the vice presidency. Remember, it is republicanism and democracy that are the principal tenets of our country. Such a myopic view obviously fails to consider a different yet equally plausible threat to the government posed by just a partisan potential of a large and growing bureaucracy. Just because of the possibility of a president abusing his power does not really merit the changing the very nature and very language of our constitution. And lastly, no one is really indispensable in running the affairs of the country. Just because a president is able to run and the possibility of him winning for vice president does not totally exempt him from being accountable and responsible for all his actions. Remember, the immunity for these public offices only refers to acts or executive acts they committed or did in line with their office. All other acts are already covered by our statutory laws and the Constitution at that. And for that, we are very proud to propose. Thank you.
May I ask the Honorable Attorney Leonard Mann to proceed, since I understand Prosec Ventura has been out in the Zoom room po.
All right, so this, sir. So interpolation?
Yes po.
Counsel, lang, you may proceed with your interpolation.
Thank you, Your Honor. Good morning, Madam Speaker.
Good morning.
Madam Speaker, is it your position that the democratic principles of this nation sees a special stage or place for the president running for vice president?
Come again, Mr. Speaker. I was not able to.
Is it your proposition that the democratic principles of our nation gives or sees a special stage or place for a president running for vice president after his term?
It's not a special power. It's the general rule of democracy, Your Honor.
I see. Do you believe that voting for a president is a democratic exercise, giving us a democratic choice?
Yes.
Yes? Okay.
Yes.
Therefore, a president running for vice president has already been accorded of a democratic right to be chosen when he ran for president.
It's democratic when you allow him to run for presidency. That is in line with the principle of democracy itself, Your Honor.
Therefore, there is no longer a need to accord the same person of another opportunity.
Not necessarily. You're depriving him. In fact, you're depriving him of the right. And that
He's already been given one.
No, not
Okay,
necessarily.
next question, Madam Speaker. Which do you think is a better choice, a tested leader or a new and innovative one?
It depends on the electorate, Your Honor. That is
Yes,
the power
both can be, but both can be a good choice, right?
Yes, if the power of the electorate do so.
Therefore, assume that you choose the former, someone who is a former president running for president. Do you think that the vice president now will no longer influence the next administration
That
as to their
probability, Your Honor,
policies?
is usually exclusive. It can or cannot happen. It's very speculative.
But it may happen.
Yes, of course, but it's
And as
speculation.
a vice president, he has all the leverage to do so.
All public officers have the leverage to
And
influence
that
what
he
are
can disrupt the evolving policies and developmental strategies of the next administration.
not necessarily, Your Honor. That's why we have separation of powers and mechanisms.
Your, your time is up. Counsel lang, you may proceed with your speech.
Power is powerful. To have to experience its produces, one must be God not to want more of it. How much more being the most powerful person in a nation of more than 100 million and more than 7,000 islands. Your honors, the affirmative side in this debate is supposed to have proved to us that it is worth giving the vice presidency to a person we have already tested as president instead of 100 million more. To allow the president to run for vice president after his term is impractical for two reasons. Allowing the president to run for vice presidency after his term is only inimical to our relations with the other nations, respective of the evolution of policies and that of the international relations of states. Also, it is impractical to allow a sitting president to run for vice president after his term because it only dilutes the very purpose that the vice presidency is made for, as well as the constitutional provisions on suffrage and other statutes on elections. It is also impractical because the intention to run after a fixed term in the second highest position of the land is a questionable intention. Your honors, the vice president of the nation is basically a message sent to the international arena. Whoever sits there says a thing. If the president and the vice president are from a party or the same party, it says that there can be congruity. If otherwise, it says that there may be plurality, if not with policies, then at least in the ideas or in politics. This is what we get when the Constitution states in Section 3 of Article 7, the Vice Presidency may be appointed as a member of the cabinet. Such appointment requires no confirmation. Now, Your Honors, what do we make of this? Yes,
Mr.
Your Honor.
Speaker, kindly answer either yes or no.
Yes, Your Honor.
Do you agree that 6 years are too short for a good president?
No, Your Honor, because our Constitution provides that we should give others to either make a choice of continuing the policies of the former administration or making new ones.
Do you believe in the legal maxim vox populi vox Dei?
Of course, Your Honor, but we will have to see how the innovations and the changes in the next administration, for instance, would affect the kind of policies that we do have in the current administration that would be changed by the coming administration.
Thank you. You may proceed, Mr.
Speaker. Yes, Your Honor. Allowing a sitting president to run for vice president after the end of his or her term is simply saying that a former president may run the country as he wishes without consideration of the evolution of states' relations, especially when a VP is one party with the other. Dean Mel Santamaria insisted in one of his columns that it is important for us to assume that there is vagueness in the phrase any re-election. The spirit of the Constitution leads to no other conclusion but that when an incumbent president's term is over, he or she should not be allowed to have any constitutional influence at the highest level of government in the next administration. To allow it will create an opportunity for a previous president to either provide instability within the government or worse, to make the president nothing but a stooge. This brings me, Your Honors, to my next argument. It is impractical to allow a sitting president to run for vice president after his term because it only dilutes the very purpose of the presidency. May I bring our attention to the case of Porminto versus Erap Estrada and the Commission on Elections. The court provided in that case, Your Honors, that in that case, no definite, concrete, real, or substantial controversy touches the legal relations of the parties that has adverse legal interest. Therefore, it is established that Erap should be allowed to run for presidency once more. Now, I understand that this is a different case, but the case provides that there be an adverse legal interest resulting to a definite, concrete, real, or substantial controversy. The court may have ruled otherwise if this was found in Arab's case. Now, Your Honors, what we are debating in here in a case is of first impression in sense. Therefore, it is important to ask that if so allowed to run for vice president after his presidential term, will there be no concrete or definite or real or substantial controversy? Actually, there can be. What that is in itself the legal interest or protecting this country's national interest. Now, how is this a matter of national interest? Well, we are talking. Yes, Your Honor.
Do you believe that the term any re-election referred to the provision in the Constitution which says any re-election refers to the position of president?
I think we have to look at the succeeding words that were used in the same provision, Your Honor. Not necessarily, Your Honor, because the term any antecedently refers to the two previously mentioned public positions in the provision of the Constitution, which is the president and the vice president, Your Honor. Meaning the word any refers to the president and the vice president's re-election. Such the controversy that we are looking for is in the national interest, that we are actually talking about the president and the vice president. And these two really have or can change the very fabric that makes our country run. And when we allow a vice president to run, a sitting president to run for president, it's as if we're giving him all the opportunities to do as he wish. And as we say, power is powerful, Your Honors. Thank you.
Proceed,
Okay.
I think my time is.
Okay, thank you so much. Third speaker on the negative side, Mr. Muhammad Ayman S. Langlang. So may we now call on Akmida D. Mamakota for his interpellation.
Thank you, Your Honor. Good morning, Council.
Good morning, Council.
Okay. Are you aware of Article 2, Section 1 of the 1987 Constitution?
Yes, but I have to read.
And so you would
Enlighten me,
agree.
please.
Okay. So you would agree that since all government, all government authority emanates from the people. Am I right?
Of course, that's right.
Yes. So does this also mean that the people are empowered to select their leaders? Yes or no?
Do you mean to say that at all
yes
times?
Yes or no, Council? Are
of
the
course,
people empowered to select their leaders? Yes.
Of course,
Do
yes.
you agree with the concept of casus omissus? Are you aware of that?
Can you enlighten me again on it?
Let me enlighten you. The provision provides that in drafting the laws and constitution for that matter, what is not included in the law cannot be provided for by the courts. Do you agree with that?
We already argued on that we think the vice presidency is included in the term any.
Next question. Do you agree that prohibiting the president to run as vice president in effect provides another qualification for the seat of vice presidency?
No, no.
But that is what you're trying to do because you will disallow a person to run for vice president if he was a previous
we
president.
have provided qualifications and we think that those are enough to propose
Next
our...
question. Do you agree that the state shall guarantee equal access to opportunities for public service?
Of course.
Okay, as that is enshrined in the Constitution, do you agree that unduly limiting the candidates runs counter to the principle of democracy?
We think this is not unduly limiting of an opportunity.
Yes or no?
No.
Please answer. So if it's not limiting the democracy, then what are you really trying to do, right? So lastly,
again,
do you feel President do you fear that the possibility of the president winning as vice president will just result to an abuse of power?
We already gave the qualifications that we think would result for on the election of a president to vice president. Yes.
Don't you think that that is just a speculation? One of
I don't think so.
Or the other possibilities that might.
I don't think so.
Okay. Your time is up for the interpellation, Ms. Akmida Di Mamakota. May we now call on the rebuttal speaker?
Your Honors and my co-counsels, we think that democratic states are strong and vulnerable all at the same time. And sometimes the result of our elections are controversial because voters have different opinions and different plights. And no matter how much we disagree with election results, this does not mean that our constitution is wrong. This only means that our public officials is a reflection of the people who voted for them. And that is the product of democracy. We need to learn from that. But to assume that the Constitution is innately flawed is an insult to the people who fought for the rights that we are enjoying right now. First rebuttal. They argue that on the concept of term limits, which we aware is very different from the call of this debate, because term limit is violated only if you are serving the same office, which in this case is not so. There was a lack of middle analysis coming from negative side to prove that automatically the consequences that they are afraid of will automatically result from the election for vice presidency. They also argued that this will discourage potential candidates. Another logical leap, because if the former president they are trying to ban from running is so bad and really corrupt, all the more that candidates will be encouraged to run against him because they do not want to elect him to vice presidency, right? So in fact, if the person they are trying to ban from running is corrupt, it's also possible to assume that people will not vote for that person. The whole point anyway is where it's important for the people, the pulse of the nation, to actively participate in that political decision making. If we summarize their case, they averred on the possibility of corruption, the alleged advantages, and the probability of dictatorship, all of which requires a very heavy burden of proof in any court. But they did not give the same type of engagement to our case, where we told you that this is not for the COMELEC to modify the requirements necessary to run for vice presidency, especially if there is no constitutional provision that is necessarily prohibiting it. So, Your Honors, we understand and we agree to the fears and apprehensions of our opposing counsel. Let the record reflect that the Philippine history has been subjected to series of colonizations and dictatorships, one which tested our desire to live in a state where governments do not dictate our rights to participate in political decision-making process. We reject the idea that they don't want to allow a president for vice presidency on the ground of democracy. We think that their arguments are hiding under the cloak of democracy, but innately they are doing the same type of dictatorship that we are afraid of. We do not recognize the idea that the Constitution should only be applied when it's convenient to our personal whims. We think what they're doing is similar to this kind of policy. We think what they're doing is the same fears necessarily that we want to protect our electorates for. For all these reasons, MSU Iligan is very proud to propose.
Okay. Okay, thank you very much, rebuttal speaker of the affirmative side. Now may we call on the rebuttal speaker of the negative side.
Your Honors, there are 3 points of clash that transpired in today's debate. First, on which side do we realistically approach the concept of democracy? Because if we look at the concept of democracy on the affirmative side, it is something that is absolute, something that is anchored on a perfect world. They never conceded to the fact that suffrage or even democracy are actually prone to abuse of power and actually alteration. We say that they bank on the idea of how perfect democracy is and neglecting the idea that the same can actually be abused, like what happened in our history if we look back. They said from the first speaker that democracy should not be limited. And on the second speaker argued that it is somehow limited. But if we critically look at the third speaker, she said that their proposal is upholding democracy. We say that democracy should not actually be short-serving. That is why we need to actually protect it in the long run. It is actually our proposition from our side that democracy is somehow limited and it is not absolute. This is evidence, again, like what I said before, that the qualifications of those who can run and who can be vote can actually be seen in our laws. We don't see why it can be applied or why it cannot be applied in the present case where the state wants to bar the president from running for vice president to protect and uphold the term limits and the welfare of the people. on the second point of clash, Your Honors, on which side do we best protect the people? Because on their side, they never mentioned on their mechanism as to how to protect the people, especially they conceded that there is a chance that what happened before could actually transpire again. They only argued how important democracy is without recognizing that there are repercussions if we actually allow the president to run for the vice president. And this is something that is not baseless, because as we all argued, this already happened before. But they simply say that, we can impeach the vice president or president, and we say that this is not actually a solution and this is not preventive in its nature. On the third issue, Your Honors, on where do we best forward an acceptable interpretation of the law, they say that there is no express prohibition to prohibit the president from running to vice president. But we opine that there is, because of the use of the word any after the words president and vice president. And in case of ambiguity, Your Honors, we look into the intention of the law, and by virtue of the mandatory succession and the rationale behind term limits, we are very proud to negate, Your Honors. And we say that, Your Honors, that the president cannot be allowed to run for the vice presidency. Thank you.
Okay, thank you so much, rebuttal speaker of the negative side. So can we now request for the host to...
We will send you to a separate breakout room to deliberate.
Okay, yes, thank you.
Our esteemed adjudicators to please go to the breakout room for deliberation.
I think the adjudicators are back from their breakout session after a very thorough deliberation with the result. May I call on the MC?
Okay, after the announcement of the winner for the third round, um, the floor will be directed to the chairperson of the 2021 Dean's Cup to give us the awarding of tokens. Thank you.
May we now call in the chairperson of the panel of adjudicators for round 3 of this 2021 Dean's Cup Intercampus Debate Tournament to announce their verdict and their significant points from the adjudicators.
Okay, thank you so much. First, before we will announce the winner and the best speaker, can we have an insight or at least a message from my fellow adjudicators? First, Sir Ali. Sir Kali.
Thank you, ma'am. This event, high level in performance. My part, it's my first time activity. I told Ma'am Nabs, the Dean, sabi ko, hindi naman ako debater, no? I'd rather argue before Court of Appeals. The fact na kailangan you always maintain, no, like in moot court, you always maintain the respect with the court, no, and preferably, no, nandun yung the selection of the language is really important. Sometimes the idea of your proposition, pero you have to admit reality. No? So I think that to say thank you to opportunity also and fellow adjudicators. Salamat.
I'll go next.
Yes,
So
sir.
I would like to congratulate all the speakers from both sides, positive and negative. We really had a hard time tabulating your scores because it's really close. The fight's really close. You all did great. And one thing that I would like to say is in this online platform, again, we connect, we engage with our audience, with our opponents, with our adjudicators by looking at our cameras. So make sure, don't forget to glance once in a while. And may I suggest to the speakers to memorize portions, just portions of your speech, particularly in your introduction, in the more important parts of your speech, in the body, as well as in your conclusion, so that you will be able to establish eye contact when you deliver these parts of your speech, and perhaps do some hand gestures to make your speeches more powerful. And in line with this, I would like just to point out, well, we're in the southern part of the country, so please take note of these pronunciations of these words. We say counsel, counsel, not council. Okay, it's for a lawyer, it's counsel, not council. I heard the word ambiguous. Ambiguous, it should be ambiguous, meaning it is not clear. So it is ambiguous, not ambiguous. And the proper word should be circumvention. Circumvention or circumvent, not circumnavigation or circumnavigate. They are two entirely different words. Other than that, congratulations to all the speakers. Keep speaking, keep practicing, and keep debating. Thank you.
Thank you so much. Thank you so much, Sir Man. Okay. Actually, sometimes I'm also a victim of this pronunciation in I and E. We apologize, sir, because we're from, Bisaya thing. Okay. So, of course, I'd also like to congratulate the both teams, MSU Iligan and MSU Marawi debater. And of course, I am impressed with the performance of MSU debaters. And of course, I hope and I'm praying that soon these MSU debaters, we can view them to the ANC square of firm debates. So good luck, and as Attorney Man said, continue to practice. So I think I have no more insights to give us, except also those in the breakout room earlier, we have discussed that sometimes debaters should think on the hint from the questions of the adjudicator, especially earlier when Attorney Man asked about the ambiguous or ambiguity of the provision in the Constitution on the running or not allowing the president to run or for re-election. I think that is an idea or a clue or a hint from Attorney Man on the discussion on the provision of the Constitution. If it is not clear, if it is ambiguous, then I think the framer or the intent of the framer of the Constitution must be reviewed. And I appreciate the rebuttal speaker for getting the clue. So may I announce now the winners or the winner? So with a split decision, parang boxing ni Manny Pacquiao, with a split decision, the winner is the negative side, the MSU Marawi. So congratulations to MSU Marawi. And the best speaker. So actually, we have a very hard time, or the adjudicators have a very hard time in discussing who will be the best speaker, since the three adjudicators have different best speakers. So the tabulators did the job for us and calculate based on the scores given by the adjudicators. And the best speaker is Mr. Muhammad Ayman S. Langlang. So congratulations to all the winners.
Okay,
Thank you
congratulations.
so much, prosecutor.
Congratulations. May I
Sorry.
now call on the chairperson of the 2021 Dean's Cup to read us the citations for the token of award. Thank you.
May I request the tech support team to please display our virtual token? We will have it delivered to you po, dear address, in the following days. So to read the citation, This is our token of appreciation po for gracing your time and effort as one of the adjudicators for this year's 2021 Dean's Cup. Certificate of appreciation, please. Certificate of Mindanao State University College of Law Iligan Extension Campus. Certificate of Appreciation is awarded to Attorney Faisal Pakalnakali for his valuable time as adjudicator in the 2021 Dean's Cup Intercampus Debate Tournament held virtually on September 26, 2021. Signed by Attorney Annabel B. Cañizares Mindalano, Dean of the Mindanao State University College of Law, and Attorney Michael Cesar A. Advincula, the advisor of Mindanao State University, Iligan Extension Campus, Debate and Moot Society. Same citation is awarded to Attorney Leonard Mann, as well as to Prosecutor Mary Grace Ventura. Thank you so much, dear Adjes, for your time and for imparting a lot of knowledge, especially to the debaters. Now, this time, I would like to call on our very own Dean for her to announce the winner of this year's elimination round and who will proceed to the championship round that's scheduled this afternoon. Dean?
Good afternoon, everyone. It has been a long morning and apologies. Yeah. Good afternoon, everyone. It has been a long morning and it will indeed be a long day for all of us in celebration of Law Week and the MSU Diamond Anniversary. And I would like to extend my warmest congratulations to all the debaters for a job well done, for a commendable battle of words and wits. This is just our second Dean's Cup, but it feels like we've been doing this for quite some time. I know some of you are not in a long time stint in debating. However, it also looks like and sounds like you have been doing it for quite some time. That is how you exhibited a good job in the course of our elimination rounds. So to all the three campuses, the debating teams, congratulations. And apparently, because this is a tournament, we have to declare winner, not really winners, because I believe that you are already winners in your own rights. In fact, you are the representative of your campus. So you are already primos inter pares. This is just an exercise to nurture intellectual discourse. That is my belief. And I believe also that we have a good future for this kind of platform for our students to nourish their critical thinking and analytical skills. So having said that, I am actually trying to prolong the announcement because it's both a joy and quite sad also, because we have to just announce two teams who that will proceed to the championship round. And I don't have any choice. I need to drop the axe. So I'll just do it quick. Ladies and gentlemen, the two teams that will proceed to the championship round this afternoon, which will be held after the legal forum, will be Marawi campus and Iligan campus debating teams. And here are the overall scores. So we have, based on the cumulative scoring of the three teams in the course of the elimination, we have ranking at first, MSU Marawi, ranking second, MSU Iligan campus, and we have, of course, the equally able MSU General Santos. Those are just figures. For me, in no way do they define your capability as debaters as public speakers. So I hope to see you in succeeding battle of words and wits of your college and your campus and intercampus as well. So the affirmative side, President Charity, the affirmative side will be.
I think we will still have to ask the qualifiers, Dean, to remain after this for a very,
All
very
right.
quick
Okay, so that's it
identification.
for me. Okay. So good luck to the, what's this? Good luck to the qualifiers for the championship round, and see you after the legal forum for that round. Press chat. And by the way, I would like to thank also the adjudicators. Thank you so much for your time and expertise and effort in adjudicating. So I would like to confirm, are we capping already our elimination rounds? Are we capping our elimination rounds already?
For a while din parang na-disconnect si
Yes,
person.
yes, Dean.
Yes, because I believe justice is already in the legal forum. So I beg your indulgence, really. Will that be okay if we will end this already, and then you can discuss in another platform the details for the championship round, press chat? All right.
Opo
Thank
daw
you so
din.
much.
Capping.
Exit.